The January 15th County Commission meeting will please come to order. We have the invocation this morning by Pastor Roger Ball from the Emmanuel Church, and the Pledge of Allegiance by Commissioner O'Brien. Please stand. Hey.
Good morning, commissioners and staff and this great community. I appreciate the privilege of opening us up with a conversation with God. There was a fellow by the name of Reinhold Niebuhr who had a conversation with God, and he recorded the words, and at least the first part of his words are very familiar to us. They're called the Serenity Prayer. But very few people have heard the entire prayer that he wrote, and I'd like to open the proceedings today with that prayer. God, grant us the serenity to accept the things that we cannot change, and the courage to change the things we can, and the wisdom to know the difference. Living one day at a time, enjoying one moment at a time, accepting hardship as a pathway to peace, taking as Jesus did this sinful world as it is, not as I would have it, trusting that you will make all things right if we surrender to your will, so that we may be reasonably happy in this life and supremely happy with you forever in the next. Amen.
Amen. Please join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Proclamations and presentations. We have a presentation today by David K. Roach, Executive Director of Florida Inland Navigation District. Good morning.
I brought my boss with me this morning.
Agenda.
Who you may know.
David's being very kind. Morning, Commissioners.
Morning.
As you know, I've had the privilege of being on the Florida Inland Navigation District as this county's representative for the past, going into my third year. And today it's my privilege to introduce David Roach, our Executive Director, who's going to tell you about the activities of the district in our county. Thank you.
Thank you, Commissioner. Good morning to all.
Good morning.
Thanks for having me. Just real quickly, I haven't met most of you. I'm not sure exactly what you know about the Florida Inland Navigation District, but real quickly, the Navigation District is an independent special taxing district created by the Florida legislature in 1927 to be what's known as the local sponsor of the Atlantic Intracoastal Waterway Project here in Florida. We're structured like a water management district that you may know more about. We have a commissioner appointed by the governor from each of our 12 counties along the east coast of Florida. We levy a real property tax on all property within those boundaries, inclusive of the entire counties. Our property tax currently is 0.0345 mils, which is $3.45 on $100,000 of value. And we use that money to work with the federal partner in the project, the Intracoastals, the federal state project, to manage and maintain the Atlantic Intercoastal Waterway for 400 miles along the east coast of Florida. And so with that, I'd like to walk through this little status report that I've provided to you this morning. The number one thing we do, again, is managing and maintaining the Intercoastal Waterway. And to maintain that navigability, we have to have a dredge material management plan to manage the dredge material. And you see here that we completed the plan in 2002. We bought 3 properties and completed that acquisition also in 2002. Over a 50-year period, we're going to dredge 318,000 cubic yards of material from your 24 miles of waterway channel to maintain it. Our next project's going to be up in the Sebastian River area in about 2010. As you may know, we're working with the Water Management District right now to demuck the Sebastian River. Currently, a lot of that muck has been flowing out of the river into the Intracoastal Waterway, so we have some siltation problems there from that. So once we complete demucking the Sebastian River, then we're going to dredge that area of the Intracoastal. You see the maps that we've provided. We've divided the waterway into 3 dredging units, and we have a management facility for each of those dredging units, and we're looking to build the most northern facility at a site called Duck Point here next year. And I wanted to point out to you that located on this Duck Point site that we bought from the Vickers family is the remaining portion of the old Sebastian train station. This historic structure is there, and we're looking to work with someone to relocate that off of our property to another public property where it can be enjoyed by the public. So if you have any ideas in that regard, we've been trying to work with the Historical Society and other folks to find a home for that facility. So we'd like to move it before it accidentally gets damaged. We spend about $16 million a year maintaining the 400 miles of intercoastal waterway, and sometimes we're asked, is that a good investment? So we've done some economic studies of our waterway, and you see our brochure here and our facts and figures on the Indian River County section. You've got 152 waterway-related businesses here in the county, employing over 1,100 people, $29 million in salaries, with a total economic impact of $80 million. Our studies show that the presence of this deeper waterway increases property values here in the county by up to $724 million, which then other governments are able to levy taxes against. You currently have about 11,000 registered vessels in the county, plus a lot more visiting vessels. Just so you know, overall, throughout our district, the waterway generates $18 billion in economic output, 220,000 jobs associated with that. As most of you know, we have an assistance program where we return about 80% of Indian River County tax dollars that we collect back to the communities here. That amounts to about $400 and some thousand available each year for these assistance program projects that help provide access to the waterway for our mutual constituents. We've provided a listing of those here in the report with a map showing you the location of those facilities, and we're looking forward to seeing that Oslo Road boat ramp come back to us in this next cycle for funding. And you can see last year we worked with the City of Sebastian on their Main Street boat ramp. Last couple programs here, we have an assistance program. We provide funding also to state and regional governments who work here in Indian River County, such as the Sebastian River Muck Removal Project with the St. Johns River Water Management District. And then we have a public information program for our constituents concerning the waterway, wherein we provide over 500,000 pieces of free public waterway information each year. So with that, I'm going to end my little status report and entertain any questions that you may have, and just comment that we very much enjoy our relationship with Indian River County and the communities here within the county, and look forward to partnering with you in the future on other waterway projects.
Thank you very much. Any questions, Commissioner?
Yes.
We'll start out here.
One statement, a question, David. The Oslo boat ramp, on Monday, we hand-delivered our application to St. John's, and so we are moving forward with that. I know that we got an email from Bruce, and we'll schedule a meeting to meet with our commissioner to get that thing moving forward again, so we look forward to doing that with you all. Question, do you guys have any involvement on the manatee signs in the lagoon?
We did from 1990 through last year, and I was successful in transferring that program to the Fish and Wildlife Conservation Commission.
Okay.
So I can give you their contact information.
I can get that, yeah. Okay. Thank you very much for all you guys do.
Commissioner Davis?
Yes, ma'am. Thank you, Madam Chairman. Mr. Roach, what is the I see we've got a piece of parcel that looks like to be about 40 acres north of 12th Street, east of Indian River Drive. Then we have a piece up in the, I'm going to say the Winter Beach area, north of Hobart Landing. Then the Vickers Grove piece. And I understand that I think I understand that the Florida Inland Navigational District has purchased those sites for spoils from the dredge material as you get it out of the river.
Correct.
I've had several people inquire, especially the parcel down off of Indian River Drive, about public access as far as some trails. It's beautiful hammock in there, and I don't know whether I kind of would like to know a little bit about the long-term use of that. Obviously, I don't think you're going to uproot some of those oak trees, or I hope you wouldn't, to use it for spoils on the entire site. Or what is the plan with some of that? And what is the possibility of having some limited public access in there for use as a park, perhaps?
Today, we're required to manage dredge material with the dike system to dewater that material. The plan on all these sites is to use roughly half the site for that purpose and leave the remaining half of the site in natural condition to act as a buffer to our neighbors. Dredge material used to be called spoil, and we used to look for a place to dump it. Times have changed. It's now a resource to be recovered and recycled, and that's how these sites are going to be developed. With 50% of the site remaining in a natural condition, there is an opportunity for public access and use. As you may or may not know, we participated with Indian River County in purchasing the property just south of us on Indian River Boulevard, and that now is a jointly owned property between the Navigation District, the county, and the Water Management District, and that would be, an excellent area to provide this waterway access through.
Just south of the IR-14?
That's correct.
Yeah, Mr. Chair, excuse me, Commissioner, that is what we call the Flynn Tract. It's about 37 acres. It was acquired, as Mr. Roach has indicated, three-way jointly between Fine, St. John's, and the county in the late 90s, and it is one of our lac sites.
That's for conservation.
Right.
And so we're limited in the amount of passive recreation allowed in that, or what's?
It's subject to what we typically would allow would be limited public access, trails, that type of thing.
Is any of this, I noticed, I don't know how current these maps are, but I noticed that Grove is still predominant. Is this leased out? Are you managing it? Or?
No, these groves are not currently being managed.
There's not much growth.
They're not currently.
Are you planning to push and shove?
Yeah.
Are you planning to push the grove out?
Yes.
The trees?
Correct.
Yeah.
So you have a management plan, and are you going to replace anything? Or are you just going to leave it raw?
We build a management facility for the dredge material, which is a basin with a dike.
And I'll just go one last question, then we can move on, Madam Chair. I've had somebody approach me about donating some funds to improve these two sites for limited passive recreation. And so I guess really I don't know where we would go from it, but it was a large sum of money that this individual suggested because he wanted to do it. His wife wanted to do it, and that was always a good reason to do things. But I found, in doing the research on it, I found that it was fine, and I did not just know how much y'all had planned on using, if you're going to use the eastern, the western, or the center part of it, or what you have in mind there. But especially in light of us having the South Point that we bought back in 1990, it would be a great place for some passive recreation. It's a beautiful area of the county right in there, and I understand that you're going to need some of it, but certainly I don't think all of it, and would like to perhaps to investigate whether or not we can do something jointly together there.
Yeah. If we can work with you and your staff and Roland, maybe there's a plan we can put together.
Okay. Thank you.
Thank you. Any further questions? Thank you for coming this morning. We have any deletions to the agenda or emergency items?
Yes, Madam Chair. I have an item, item 13B1, regarding travel expenses for Dr. Backus that came as a recommendation from the Agricultural Advisory Committee that we had last Thursday. and I'm acting based on their recommendations.
Would you like to put it under your matters?
That'd be fine. Yes, ma'am. 13B.
Do I have any objections? May I have a motion?
Move to accept or amend.
Second.
All those in favor?
Aye.
Passes unanimously. Thank you very much. So we'll put that under your matters. Approval of the minutes, regular meeting December 18, 2007.
Move to approve, Madam Chair.
Second.
All those in favor?
Aye.
Passes 5-0. Reports on file under the consent agenda. Any item under consent agenda you would like pulled?
Madam Chair, I'd like to pull item C.
All right. Any other items? May I have a motion?
Motion to approve is amended.
Second.
Any discussion? All those in favor?
Aye.
Passes 5-0. Thank you. C, Commissioner?
Madam Chair, item C is just a resolution.
Can we read what C is,
okay.
please?
It's a resolution adding members to the Economic Development Council, and we had requested 3 positions, and in writing this up, they omitted 1. And so I'd just like to move approval of the resolution with the inclusion of a member from the Workforce Development Board.
Do we have a second?
Second.
Any discussion? And you'll bring that back next time?
We can, or just, they can
Or just
insert,
add it.
I think it'd be just.
Modify the resolution
let's do
for
it
your
that way then.
signature.
Yeah, that'd be easier.
All those in favor?
Aye.
Opposed? Passes 5-0. Thank you very much. Public items, public hearings, none. Public discussion items, none. Public notice items. Notice of scheduled public hearing January 22, 2008. Public notice of public hearing to adapt an ordinance to designate an official county seal. Memorandum dated January 8, 2008, legislative, page 126. Departmental matters, community development, consideration to authorize pulling compliance bonds for noncompliance with site plan approval requirements relating to the Tom Hammond Sand Mine and the Ranch Road Lake Sand Mine, quasi-judicial. Memorandum dated January 8, 2008, pages 127 to 151. I'd like to, at this point, ask our attorney to lay out the process and the ground rules, please.
Thank you, Madam Chairman. Late last week, the Code Enforcement Department made observation of the coming and going of trucks at 2 of the sand mines off of 82nd Avenue, and based on those observations, the Code Enforcement Chief, on behalf of Mr. Keating, the Community Development Director, notified the 2 mine operators of a pending forfeiture of their compliance bonds. The compliance bonds are in place, among other things, to guarantee that all conditions of site plan approval, including but not limited to confining the trucks to the designated haul route, are complied with. If there's a violation of the designated haul route, then the compliance bond posted for the mine, which is based on its $1,000 per acre of the site, can be forfeited. The letters of credit that secure this bond for compliance with site plan have a provision in them that require a resolution of the Board of County Commissioners which finds a violation for failure to comply with the haul route condition, and upon your adoption of that resolution, the staff would proceed to call the letters of credit for the compliance bonds. The ordinance provides that the Community Development Director will notify the permit holder of the noncompliance and pending forfeiture, and that notice includes appeal procedures. The board, at this point, can make findings of fact after hearing from both our Code Enforcement Office and the permit holders to determine whether or not the violation did occur, whether it was insignificant. You have the discretion to return all or part of the bond, and you can, well, the effect of calling the bond is that the mines can no longer operate until they post new compliance bonds. One of the requirements of the mining permit is that there will be in place both compliance and restoration bonds. If the compliance bond is pulled, the mines will not be able to operate until such time as they post renewed security for future compliance, which could be a cash escrow or a letter of credit. But this is in the nature of a quasi-judicial hearing. You're going to be making findings of fact as to whether our code office was correct, whether there are circumstances that have not been presented to you. It's a little different than many other quasi-judicial matters we have, where you have an applicant before you and perhaps some neighbors in opposition to an application, where our staff is acting as sort of a neutral advisor to you of what their findings are. In this case, they themselves are bringing the case for a violation, and because of that, I've asked them not to be in contact with you outside of this hearing, and as well as the operators. And the reason being, whatever decision you make should be based on facts that not only you hear, but the operators and our staff here. And decisions aren't made based on one-sided conversations where neither side really has the knowledge of what your decisions are based upon. So with that, I'd turn it over to our staff. Because this is quasi-judicial, the operators and the staff, after the presentations, will have the opportunity to question each other or to present evidence of their own to rebut whatever conclusions the other may draw.
Okay, I have a question, please, a procedure. This is not under a hearing matter. This is under a department matters. So at this, and in the backup material, it was a resolution we were going to approve or not approve.
Right.
So are we now proposing to have a hearing right now?
This is not a public hearing. This is just findings of fact that you're asked to make, where both the staff will make their case for the fact that a violation of the haul routes did occur, and the operators have the opportunity to state either that the violations didn't occur or that they were insignificant.
And they would have an appeal process in 15 days?
Technically, they do have a right to file a written appeal. My understanding is that no written appeal has been filed at this point. So you could look at this as just a matter of whether you want to adopt the resolution finding a violation, authorize the staff to call the letter of credit, and hold the appeal at a future date. I think that all the parties are here, and it would probably be more economical to have the hearing now. But if that is the case, it might be worthwhile to ask whether they'd be willing to waive that future appeal or whether they want to reserve the right to file a written appeal at a later date.
Madam Chair?
Yes.
Mr. Collins, that appeal would be back to us?
Yes. Same issues, which is why I think if everybody's here and ready to go, it would make more sense to deal with it today.
Any other questions of our attorney at this point?
Comment.
Yes.
What I'm hearing from Will is that the procedure is to file a written appeal and then appear back in front of the commission. And I, for one, would like to see us follow the rules. And if that's the case, they've had an opportunity since they were notified to file a written appeal.
Well, they have 15 days to file the written appeal, so they're not precluded from doing so.
No, I realize that, but I think that they should file the written appeal. And then we've got something in paper and bring them back at the appropriate time and just follow the rules we've established rather than waiving the rule and saying we'll have the appeal heard today without notice and without seeing where they're coming from.
I can understand that you'd want the basis for their appeal in front of you in writing rather than just winging it.
Any further questions of our staff at this point? Then
I'm wondering if I could be heard just on a point of order, if you don't mind.
attorneys, the process is now to listen to our staff, but if there are no objections from the commission, I will, you don't need to be sworn because you're an attorney, is that it?
That's
my recollection from the city. Is that still in the county?
Yes.
Okay.
Thank you.
Name and address, please.
I'm Eugene O'Neill, Gould Cooksey Fennell Law Firm, 979 Beachland Boulevard. I represent Ranch Road Mine,
one of the two parties charged here today before you. I request two things. One, before staff begins its presentation, because they are bringing forth alleged violations involving two minors, we would like the matters separated, because my client does not want to be painted with the broad brush of other mines, other alleged violations, other trucks, other truck drivers, and we have a right, we think, because of the seriousness of what's at stake, to confront our accusers and address anything addressed only to our alleged violation without complicating it, involving others that are not in the slightest bit germane to our issues. Secondly, as far as this appeal process, we were charged. We were told here to come and defend. We have all our witnesses. We're ready to go forward. As far as an appeal, I'm hoping a further appeal isn't necessary. I don't know why we would appeal now, since we haven't been found guilty of anything. So we would like to be heard on the merits, see where that goes, if appeals are necessary, which I don't think it will at the end of the day, but we don't want to be tied in the staff presentation to another violator. And I understand the other party that's here before you is requesting a continuance on theirs. So I think it's the best of both worlds, that you can go forward with ours on the merits and they can come back. Apparently they didn't, neither side got much notice, but we're ready. Whether Paul Amos, who represents the other party, wants to come forward and support what I'm saying, that he'd like his separately, but we're ready to go. I've got a dozen people that gave up today to be here to present facts.
Any questions of this?
Yeah, just kind of a port of order, I guess. Reading our land development codes, chapter 934, the community development director can make the determination of a finding of noncompliance. And I think by sending these letters, the county has done that. It's just the letters of credit that were issued by the two banks. In their letter of credit, they had a requirement of a resolution of the board that there was a default. So I think from the appeal process, that started as soon as the community development director sent the letter and of a finding of noncompliance. And so I think that's been done. So now they have, I believe, the right to be here to appeal that decision. And then we just need a resolution if we want to call it a letter of credit, which is a bank requirement.
Commissioner Davis.
Well, my question is I'd like to hear from our legal counsel about what legal counsel is saying before we go into what Commissioner O'Brien's going
Well,
into.
on his first point, I think he's right. It's one agenda item before you, but it involves two separate violations. So I think the staff should make its presentation with respect to the first one listed, Hammond first, and then hear from the Hammond people as to their point of view, make a finding on that one, and then have a separate hearing more or less on the Ranch Road Lake sand mine.
So you're saying that what he suggested is appropriate?
Yes, there are two separate issues, and you should make two findings, one with respect to whether one mine had a violation, and then with respect to the second mine, because they are independent operators.
Okay.
Any other questions at this point? Yes. Be happy to hear you too.
Yes, ma'am. Paul Amos, O'Hare, Quinn, Camden, Castellino, 3111 Cardinal Drive, Vero Beach, Florida. I represent the Hammond parties of their mine in this matter. We also agree that there are two separate mines with two separate incidents which have been alleged against each of them. We also don't wish to be painted with a broad brush and would like an opportunity to address the issues brought against my client. However, one of the concerns that we have is we've been provided with approximately 3 working days notice of this allegation, and my client's situation is a little bit different than the mine next door. Specifically, this involves trucking and transportation issues, which is going to require some fact gathering on my client's behalf in order to provide the information that I believe the commissioner is going to require. We need to look into these matters a little bit more, and that's why I'm going to be requesting a continuance of this hearing in order to do a bit of investigation. I've spoken with Mr. O'Neill regarding that because the issues involving the trucking specifically and possible noncompliance with the haul routes, these are not, at this time or at any time, they're not employees of ours. We don't do trucking. So we need to find out what happened, how it happened, who caused it to happen, and exactly what the situation is, which would possibly put any liability on my client. And then, once we have those facts determined, I can provide to the commission more information, and we can determine what liability, if any, my client actually has to the commission, and then make a determination regarding the bond.
Madam Chair.
Well, let's hear from our attorney at this point. Yes.
I think what Mr. Amos is saying is his client's not ready to make his case right now. The board is being asked by the staff to adopt a resolution pulling the letter of credit. He does have the right to appeal and could be heard after he gathers his facts, and you have the ability to make refund in total of the bond should it be pulled. But I think the reason you're here today is to follow through on the requirement to pull the letter of credit of adopting a resolution and making a finding of noncompliance. The staff will still make its case. If you pull the resolution, Mr. Amos can still come back on appeal and after his fact finding convince you that it was in error that we pulled the letter of credit, and you're authorized under the code to fully refund the bond at that point. I think he's in a little different situation. He's not ready to go. Mr. O'Neill is ready to go.
Mr. Cohn,
yes.
If I might, under the rules for mining in this particular matter, 934, it specifically makes reference to the requirement of the bonds, compliance restoration bonds, shall be posted to ensure that the site is developed, operated, restored in conformance with the approved mining site plan. Compliance bond can be assessed as penalty only to violations of site plan approval that are chargeable to the mining permit holder and those under his supervision, direction, or control. That's part of the issue that I think that the commission needs to have a full bit of information on before you make your determination and effectively stop operations of my client. The allegations by code enforcement are that there was some trucks that made an improper entrance or exit to my or exit from my client's property. There's no allegations that those trucks were owned, operated by, or supervised by my client. And I'm requesting an opportunity to make a determination specifically what that situation is. Before you effectively take the bond or funds from my client and effectively shut him down, we'd like an opportunity to obtain that information and be able to provide it to you. We believe that the sanction that's going to be imposed is a harsh one and will obviously have great effects and ramifications on my client's operation. And we'd like an opportunity to be able to provide that information before such a harsh measure is imposed on us.
Yes, Gary, we'll come to this.
Under Section F,
Page
133 in our backup, it says, and I know we're splitting hairs here, but the rules are the rules, the law is the law, and it says, and I'm not a lawyer, but any person receiving written notice of suspension of a permit and bond forfeiture may, within 15 days following the date of such a notice, enter into an appeal in writing to the Board of County Commissioners of Indian River County, Florida. Such appeal shall state the location of the property, the date of the notice of violation, and the grounds and the basis of that appeal. The Board of County Commissioners, after holding a hearing on this appeal, which should be in writing, may continue to the suspension or modification of suspension, revoke the operating permit, and so on and so forth. My understanding is, and correct me well if I'm wrong, but to just put this in perspective and to find out, and it's a matter of procedure, first, there has to be a violation, which we have from our code enforcement. Secondly, we are simply asked to hear the code enforcement's violation and determine whether or not it has validity. If so, then we vote the resolutions to take the letter of credit and bond. During that 15-day period, we should get a written appeal from both parties stating what their position is, what their appeal is, and then come back in front of us at a later date where we will hear the appeal and listen to their side of the issue along with code enforcement. Maybe I'm wrong, but I feel like we're shortcutting this thing if we grant an appeal today, and obviously I'm looking at this more like a criminal court than a civil court, but I just think that it's, if we're supposed to sit here as judges, I think, one, we should follow procedure, and two, we should be prepared with as much background information as possible from both parties prior to hearing their appeal, rather than, like Will said, doing this on the fly.
Well, I had this conversation with Will right before the meeting, because I read it the same way you did. But there are always, in your legal behavior, changes and differences and whatever. So, Will, you want to address that?
Well, it's always up to the board, how to conduct its hearings. The rules are exactly as Commissioner Wheeler stated them. There should be a written appeal. What's technically before you today is a request from the staff to adopt a resolution pulling the bonds based on their finding of a non-compliance with a haul route by 2 mine operators. There is the opportunity for the operators to appeal and get a return of those funds subsequent to this. But I think you have the decision to make how much or how little you want to hear today.
Could I be heard again, if you don't mind?
Yes, we want to knock this procedure out so we all understand it for sure.
Well, you're possibly about to give my client the death penalty, putting him out of business by yanking a bond which would yank his permit. And you would do that upon what evidence? Your code says upon a finding of noncompliance. Well, who makes that finding? I think you're going to do that, and I think you're going to see it our way. But making that finding, if that's up to Ms. Kelly Zedak of staff, and what she says is go, she gives death penalties to minors around here willy-nilly, that's a terrible procedure. I think you can interpret your code that you folks are making that finding. And whether we, because your code is written that we appeal the Board of County Commissioners to the Board of County Commissioners, so be it. But who makes that initial finding of noncompliance? Her letter, and the staff's letter, isn't of noncompliance. It's given notice of a forfeiture hearing before your board. That's what our notice is on. So we're here to fight that there was a noncompliance. And that finding has not been made, to my knowledge, unless Kelly Zedak is your judge.
I'm concerned also that you're sentencing us before we've had an opportunity hearing. If we take this in the light of a criminal prosecution, effectively we've been put on notice. We've been brought here this morning. You're going to effectively, if we proceed in the light Mr. Wheeler had mentioned, you're going to effectively pull these bonds, shut us out of business before we've really even had an opportunity to address this matter. If you're going to be making the findings of fact this morning, I respectfully am requesting additional time so I can bring in the witnesses and the evidence and provide the testimony so that we can have the hearing before you as the finders of fact in this matter. If you sentence us first and shut us down before we've had an opportunity to make those presentations, you're asking us effectively to go to an appeal based on a finding of fact, based on something that I've had 3 days' notice to put together.
Technically, the finding is made. The finding of noncompliance is made by the community development director. There's a subsequent opportunity for the board to make findings upon an appeal by the applicant. If we don't have a written appeal as required by the code at this point, the community development's finding of noncompliance is reported to you for the purpose of fulfilling the condition of the letter of credit that you adopt a resolution. Well, let's see exactly what it's saying. Your resolution is that they've defaulted under the terms and conditions of the ordinance, and that the amount of the draft represents the amount to fulfill compliance with the conditions of site plan. And this is set up as a penalty on the forfeiture. It's really a question of whether you want to accept your community development director's findings, which you have not heard yet, you've only heard from the attorneys, or not, such to call the bond. If you do call the bond, both parties have a right to appeal that decision and you have the opportunity to make additional findings that you were wrong in calling the bond and make a refund later.
Could I add one additional point, which I think is important? Let me tell you about the notice we received. This is a notice from the community development director, and it said, enforcement staff observed dump trucks. And then it goes on to say, you are notified that the Board of County Commissioners at its regular meeting of January 15th will consider pulling the compliance bond, the irrevocable letter of credit. Well, that's what we're on notice of here. To now say that we were already found guilty by Kelly Zedek and we have lost the right to our bond and we're out of business before you even hear the merits, that's not what we're on notice of. We're here to give our side of the story so that you don't consider pulling our bond. We need to continue in business, and you need to know why.
We have some more questions. Let's just a minute. Commissioner Fletcher?
I believe that we're starting to hear an appeal process before we actually engage in fact and finding. And Will, correct me if I'm wrong, is this not a non-compliance forfeiture hearing and statement of finding in fact?
Yes.
So if that's the case, if they have been noticed at this time, they know that there is a perceived or observed violation, and I think that we need to hear that violation and have that discussion and then place them in a position where the code most certainly supports under 93407 sub 5 paragraph E on, I believe it would apply that this would be a forfeiture hearing upon finding a noncompliance with the chapter or the approved mining site plan or reclamation site plan or failure to renew the bonds within 30 days of expiration. The Community Development Director shall notify the permit holder in writing of the noncompliance and the pending forfeiture of the compliance and or restoration bond. This notice shall also notice to the appeal process. Sub to that on one, Will, it says the compliance bond shall be forfeited for violating the conditions of the site plan, thus providing for an appeal.
If I may.
So we would have to actually hear this before us today, whether it's separately or collectively, and then allow for the 15-day filing process?
Well, I think the first thing you've got to do is get off the schneid and hear the staff, which we haven't done yet. And you should hear the staff with respect to Hammond first and the other mine second. You should determine to pull the Hammond mine or not first, and then go on to the second one. It may be that Mr. Amos is going to take an appeal because he needs to develop the facts further. It may be that you hear from Mr. O'Neill, but I think we're sort of going around in circles if we don't get to the staff and what we're really here about in the first place.
Commissioner Wheeler.
One last sentence in F that I didn't finish reading, but it points out again, and it assumes that we suspend the operation or take the letter of credit, because the last sentence says, the Board of County Commissioners, after holding a hearing on this appeal, may continue the suspension, which is, we should have the hearing and decide we're going to suspend it. Then we can decide at a later date, when we get the notice in writing, whether we should continue the suspension, modify the suspension, revoke the operating permit, call for forfeiture of any bonds, or reverse the decision of the Community Development Director. So I agree with Will and Commissioner Fletcher. I think that we need to hear this, and then probably the argument over whether the appeal should be is after we make a decision on the bonds. But I think the appeal should be after we get written up.
I agree with that, and I think they should be separate. And so if we will start from staff with the first one, Tom Hammond, sand mine.
Thank you, Mr. Chairman. On the separation,
And can we be sworn, please?
Yeah, would anyone who's going to give testimony here this morning on these cases, please raise your right hand and be sworn by the clerk.
Madam Chairman, just a clarification. I understand we're separating these two out and hearing them separately, but I do have one general location map that shows both mine. It's strictly for location purposes. If it's okay, I'd like to show that, even though it shows both mines, but we'll clearly present the evidence on a separate basis. Thank you. The mines in question, again, we'll be talking about these distinctly and separately, but they're on the 82nd Avenue north of State Road 60, approximately 4 or so miles north of State Road 60. We have the Tom Hammond sand mine, and then nearby to it, the Ranch Road Lake sand mine. I'm now going to present information that supports essentially what the situation is that the approved haul routes, in this case, we'll talk about the Tom Hammond sand mine, is the approved haul route for this sand mine is north on 82nd Avenue, specifically north to 69th Street and then out from there to 66th Avenue or wherever to the job site. So essentially, the main issue here is compliance with the approved site plan and getting more specifically adhering to the approved haul route. As has already been discussed, if you look, I'm going to move now over to the Elmo for a second. This has already been mentioned, but it's right out of the code, section 934.07, subsection 5, under circumstances where a compliance bond could be pulled. It specifically would have underlined, the compliance bond shall be forfeited for violating the condition of site plan approval, including but not limited to failure to confine hauling to approved haul routes. That's the specific section we're focusing on today. Further information on the approved haul route. Specific to the Tom Hammond mine, which we're now talking about. This is from the traffic study. You can see the depiction of the site to the left of what's on the overhead, and it clearly depicts, contemplates, and is consistent with the haul route that I'm explaining was the approved haul route in this case, which is limited to north on 82nd, coming and going for the haul route activity.
And that's per hour, correct? Or peak?
I believe so.
Okay.
And this is the traffic report submitted by the mine operator, is that correct?
Right.
Thank you.
Okay, the next thing I want to show you is actually from the approved site plan. Again, for the Tom Hammond mine. The graphic you see to the bottom there, that again says haul route detail. And again, it's showing the traffic, particularly here heading north on 82nd, doesn't show anything going south. It specifically says in a note also on the site plan essentially says there are 1.25 miles of unimproved county maintained road along the proposed haul route. That is consistent with it going north, would not be consistent with traffic going south since it's a lot longer. It's more like 4 miles. So all indications are, as I'm presenting it, as the approved haul route is to the north. Moreover, there's a road maintenance bond that was posted separate from the compliance bond. It was based on the characteristics clearly of the northern route, not going south. So this is all to present that clearly the haul route is to the north, not to the south. In your backup, the first attachment to your backup for this item is an affidavit from Code Officer Kelly Zedek. Kelly is here and is prepared to answer your questions directly, but in some, based on, just right from the affidavit, if you're focusing strictly on the Hammond sand mine, in Ms. Zedek's affidavit, she has listed 7 points. The first 3 points or three numbered paragraphs relate to the Hammond sand mine. First, it's an indication that she was at 82nd Avenue. She got there about 6:08 a.m. on January 9th, and she left, as it states back towards the end of the affidavit, approximately 10 minutes before 9. During that period of time, number 2 on the affidavit indicates that Mrs. Edek observed 7 trucks going into the Hammond sand mine from south of the sand mine on 82nd Avenue. She also indicates that she noted 6 trucks leaving the Hammond sand mine, turning south and heading towards State Road 60. That would be in violation of the approved haul route. She also takes note that 4 trucks did leave the Hammond sand mine during this period along the approved route heading north. So essentially, staff's position, and we do have photographs of the trucks we could show, but if you'd like, but essentially just shows trucks at the entrances so you can actually see the coloration and markings on it. Not detail markings, but the trucks. I don't have it. That's up to your pleasure if you'd like to see those. Otherwise, Mrs. Edek is here, and she can attest to her affidavit. But essentially, in summary, it's black and white in the county code. The compliance bond shall be pulled for noncompliance, including not adhering to the approved haul route. As far as the issue of whether or not the owner or operator is responsible versus, say, it wasn't their trucks per se, it was someone coming to get their product, staff's position is that it's clearly responsibility of the permit holder to make sure that the haul routes are complied with. I mean, that's, from staff perspective, that's a pretty straightforward situation, that a mining operator, whoever pulls the permit, is responsible for making sure their operation complies with that permit.
Do any commissioners have a question at this point?
Madam Chair?
Yes.
I would like the opportunity as one county commissioner to see the photos. I believe that we should see the photographic evidence that's been submitted. In addition, I had a question for Ms. Edek. Is that your customary shift, that time?
No, sir. I normally start at 8:30.
So there was some directive to ensure we had a compliance observation?
Yes, sir.
Okay. So it was to your understanding that we may have had some violations in the past?
Yes.
Well, we haven't gotten to her. We're still
I just wanted to ask Joe Baird how we got to this point. Did you have any conversation with the operators of the mines prior to this?
Oh, yes. Over the last year, we've had discussions regarding, problems with dust, the condition of the road, truck routes. We've had several conversations. We've had night meetings. Due to complaints, when the Wild Turkey Grove came up last week, a lot of the residents were complaining about trucks going south, not following the route, and the conditions. I asked code enforcement, also the hours of operation. I asked code enforcement to actually do more, to observe more activities out there, in which we asked Kelly to come in early, change her schedule, change also some public works employees' schedules, check the road in the morning, check the road in the afternoon, and make sure all the issues were being taken care of. And it was purely because of complaints by residents in the area.
And this was perhaps the day after the request, as far as enforcement time?
Actually, we had started enforcing it probably a couple of weeks before, asking that, I had calls from residents in the evening sometimes saying that the trucks, I had a couple calls that they were running after 5. And so I sent Kelly out on several occasions, asked Bob Keating and actually Kelly to make sure that we had increased code enforcement for all the complaints we had received.
But specifically, the early morning enforcement had just began, correct? I mean, this was this perhaps maybe the first week?
We've had we checked occasionally in the past year. We have because and it's not just Kelly. We'll have sometimes. We'll ask Jim Davis in the past year when we've had complaints. We've had sometimes our inspectors from Public Works out there checking the road condition very early in the morning, as well as the route trucks are going. We're using a combination of all of our resources, our staff, to try and, because our code enforcement officers have a lot of work to do. They get more than one complaint, so they have to be all over the county. So we're utilizing the staff, other staff like Public Works also to check on them.
Thank you.
Back to your presentation.
Thank you, Madam Chair.
Actually, what I'd like to do is ask Kelly to come over and just present these two pictures. She can explain. Your notes are on the back.
Okay, in the first photograph, I was actually sitting on the east side of 82nd Avenue facing north in between the Hammond sand mine and the Ranch Road sand mine. In the photograph, that is a truck that was approximately between the hours of, they started arriving about at 7:11 that morning, and it was between 7:11 and 8 o'clock that morning that truck is at that point leaving the Hammond sand mine and turning south and going towards State Road 60. In the second photograph that I took, again, approximately between 7:11 a.m. and 8 o'clock a.m., those are two trucks that pulled out of Hammond sand mine. I stayed in the same position the whole entire time. And further back in the picture, you will observe that there are two trucks using the proper haul route, and those were actually going to the other sand mine that was located further south. And as I stated, I sat in that same position between the two sand mines the whole time I was there.
Kelly, could I just ask a couple questions? Would you, again, identify yourself for the record and your title?
Kelly Zedak, Indian River County Code Officer.
And how long have you been a code officer in the county, approximately?
Approximately 9-10 years.
And then the other question, and earlier I had summarized your affidavit that you had written related to this matter. Was my summary correct?
Yes, sir.
And when you observed trucks as referenced in your affidavit and as shown in the photos, did you recall were any of the trucks specific to the Hammond mine that you observed? Did you notice if any of the trucks had fill material in any of the trucks?
Yes, I did observe a number of them did have fill material.
Okay, thank you.
Are any questions?
Yes,
Mr. O'Brien?
Ms. Zedak, just while you were there, did you observe any mine employees out there at the entrance trying to wave the trucks? Some guy would go, stop, you're going the wrong way, and any attempt to control the traffic?
No, sir.
Thank you.
Any other questions?
You're stating that those two trucks did have loads on them?
Yes, sir.
Thank you.
Okay.
In summary, and as mentioned by Mr. Baird, we've received complaints on the mining operations. What we rely on are actual observations by code enforcement staff and by county staff. In this case, we presented an affidavit, we presented the testimony, the photos. Staff's position is that it's straightforward. There were trucks hauling along the unapproved haul route. It's specific in the code that that's a cause to pull or forfeit the bond, and that's what our recommendation is.
Any questions of staff? Mr. Davis? Mr. Wheeler?
No, ma'am.
Mr. O'Brien, any more?
No, ma'am.
Mr. Fletcher?
Not in a motion, no.
Thank you very much. Is that your complete report, staff?
Excuse me?
Is that your complete report?
Yes.
I would move that we accept the resolution and approve it.
If I might, is my client going to have an opportunity to address the board with any?
Wait just a minute,
Yes, ma'am.
please. I have a motion. Do I have a second?
Second.
Discussion. At this point, the procedure is?
Well, at this point, it's up to you whether to go forward with a motion. Mr. Amos has the right on behalf of his client to file an appeal to overturn whatever decision you make if you decide to pass a resolution, or you can waive your rules which require the written appeal and hear him if he wants to be heard. But what I heard earlier was he hadn't been able to develop the facts on notice.
My concern is if this is a quasi-judicial hearing, you're making a finding of fact based on testimony provided by staff without, if I'm not going to be provided an opportunity to rebut any of it. Also, I found objectionable that there were references to alleged pre-violations, which you haven't heard any evidence or testimony to. So I'm concerned that there's going to be a taking from my client without an opportunity to provide any testimony. So really, the appeal won't really be, it's not an appeal of an original finding. It will be a one-sided finding, and then we appeal it later.
Commissioner,
you brought up, and I did too, like criminal findings. And what I'm sitting here looking at this from my perspective is there's probable cause to believe that there was a violation committed based on testimony from our code enforcement officer. Therefore, we're following a procedure and rejecting a bond, which our ordinance says that we must do based on the haul routes. Then the second part of this is, again, you have the right within 15 days to file a written appeal and then be heard and appeal that to this commission. But I don't think there's any obligation of this commission to continue the appeal today. I think we should have your written appeal to the Board of County Commissioners, and we should set a date when you come back in front of the commission, and then we'll hear both sides. This is simply, it's kind of like you mentioned criminal court. I mean, you can go out and get arrested by a police officer for a particular crime. You're not convicted, but you go to jail until you post bond if it's a bondable offense. And the same here. Our ordinance says clearly that we shall reject. And then it says clearly that you have the right to file a written appeal within 15 days. And we're just following our ordinances.
Respectfully, if I could, first appearance hearings would be to determine if there was probable cause. There'd be a bond hearing without a sentencing or a conviction at that date, and there'd be a subsequent hearing or trial to determine that. It's my understanding that you're effectively making your finding, whether it be a probable cause or however far you'd like to take it, but by revoking the bond and putting my client effectively into either a holding pattern or out of business, we're being sentenced this morning.
Well, we're following our ordinance as it's written.
Well, respectfully, I'd suggest that it states that there's to be a hearing. If there's going to be a hearing, wouldn't that be on both sides?
I believe that the code affords for a hearing under appeal.
The thing I keep going back to is the finding of noncompliance is by the Community Development Director. The only reason this matters before you is because the letter of credit requires the site draft of the letter of credit to be accompanied by a resolution of the board. So the staff, in order to get that resolution, has put this matter before you saying, we have found the violation. Please allow us to pass the resolution. We need to call a letter of credit. They do have appeal rights. They can come back. They can get their bond refunded.
Might I suggest that the letter, I think that you're referencing, is dated March 8th, and the report from Ms. Sedak says she was out on the 9th. I mean, there's several issues there that are of concern, too, that I don't think the board, or the county commission, has had an opportunity to hear.
What is March 8th?
No, the notice letters are dated January 9th, which is the same day of the affidavit of Ms. Zedek when she was on site.
The letter I'm referencing is
referring to the memorandum staff report on the agenda. It says January 8th. That's a typo. It was written on the 9th. The substantive facts or evidence in this case are consistent and are, in fact, for January 9th.
At this point, I find that we have our own attorney, and we have to listen to our own attorney or get a new attorney.
Madam Chair.
And so I would like to follow his recommendation.
Are you talking about this being dated on the 9th? That's a typo? Because if it is where everybody read it and signed it, it says that everything would be the 9th. And so that's what I'm looking for. Is that what you're talking about, where this says the 8th rolling should be the 9th?
At the very top, it says the 8th. All the
Right.
sign-offs at the bottom are on the 9th. And
that's
the
what I-
item references the 9th
Okay.
for all the pertinent
Okay.
Matter of fact,
observations.
one was signed on the 10th.
Yeah,
It
well,
was-
and that's what I'm just looking for, some kind of a,
Any further discussion or questions? All those in favor?
Aye.
Opposed? Passes 5-0. Our next item is the Ranch Road Lake Sand Mine. This is also quasi-judicial.
Before we get started on this, I don't want to have that same treatment. I want to have an opportunity to be heard before my client is put out of business. It lacks due process. It's totally un-American to take a violation away or take rights away without having an opportunity to be heard. Now, in fairness to you, in light of what you've just done, I'll be willing to call this our appeal process because we want to be heard. We want to get our side of the story in before we lose rights. So when we go forward here, we'd like to do so in a circumstance that we can present our side of the story before you would attempt to take away our business. So I'm going to be appearing before you again after the presentation, and we want to be heard on the merits. And if you want to call that our appeal now, and if you want it in writing, I'll write out right now, I appeal. But we want to be heard on the merits. Thank you very much.
Point of order.
Yes.
Will we not have to vote to allow an appeal process to be initiated today?
Well, I think what Mr. O'Neill's saying is that he has 15 days to file a written appeal, that he will waive that right to a written appeal, but he would like to be heard today as to the facts that he's prepared to present right now.
Yes, I have all my witnesses here. We're ready to present our case. We'll call it the appeal. We'll call it the initial violation. We'll call it anything. We'll waive all our rights so we have an opportunity to be heard before our business is closed.
We would have to vote on that?
I don't think so.
I don't know. It's up to the chairman. The chairman can decide whether to hear it. You, as a board, can overrule by a majority vote if you disagree. But it's
the weight is on the chair
at this point.
We'll listen to staff first. Thank you.
Thank you, Madam Chair.
Thank you, Madam Chairman. I'd like to just go back to the location map for reference. Okay, on the map, we're seeing that the area or the rectangle in red represents the Ranch Road Lake Sand Mine, which we're now speaking of. And again, and I will present evidence now and just information that similar to the previous mine we discussed, the approved haul route is to the north on 82nd. It's limited as such and not to the south. And this is the traffic impact statement associated with the Ranch Road Lake Sand Mine. And again, although there's some handwritten markup, this does show that it is again limited to going north on 82nd Avenue for the Ranch Road Lake Sand Mine. The approved site plan for the project does depict the haul route to the north, a clouded highlight, if I could zoom in. Again, it says proposed off-site haul route, 1.5 miles north to 69th Street. And again, on the site plan under notes, there are 1.5 miles of unimproved county-maintained roads along the proposed haul route. And again, that just due to the characteristics of 82nd Avenue, that all points to the haul route being limited to going north on 82nd Avenue. In your backup is an affidavit from Code Officer Kelly Zedek. And in the affidavit, it references Ms. Zedek being on 82nd Avenue on January 9th, arriving at approximately 6:08 a.m. and leaving approximately 8:50 a.m. What I'd like to do at this point is just give Ms. Zedek a copy of the affidavit. Ms. Zedek, based on the affidavit, your point paragraphs numbered 4 through 6, in particular 4, 5, and 6, relate specifically to the Rancho Lake sand mine. Would you just recite what you wrote in your affidavit on those 3 points?
Yes, sir. At approximately 7 a.m., the truck started to leave the Ranch Road sand mine, and I counted 21 trucks leaving Ranch Road and heading north on 82nd, which is the proper haul route. And I also observed 24 trucks going into the Ranch Road sand mine using the approved haul route. At approximately 8:14, I observed 2 trucks belonging to Eddie Huggins Trucking traveling southbound on 82nd Avenue, and they came out of the Ranch Road sand mine. At approximately 8:30, I noticed 2 trucks belonging to Eddie Huggins Trucking traveling north on 82nd Avenue, not using the proper haul route, and they turned into the Ranch Road sand mine.
Thank you. And I believe you have some photos, so if you would
Yes, sir.
show these on the overhead and explain again what you're showing.
Okay, in the first photo, I was actually further south of Ranch Road sand mine. I was facing north, coming from the State Road 60 direction, and at approximately 8:14, that is one of the trucks coming from, it belonged to an Eddie Huggins Trucking Company, and that was coming from the Ranch Road sand mine. And in the second photograph, also at approximately 8:14, that is just a close-up of the truck.
And the ones going north?
I'm sorry?
You got any pictures of the ones going north?
Yes. In this photo, I was actually behind the 2 trucks, facing north on 82nd, and that is them turning into the Ranch Road sand mine.
Any questions?
Madam Chair? Yes. 2 things, Ms. Zedek. One, again, at the entrance to the mine, did you observe any mine personnel trying to direct traffic into the proper direction?
No, sir.
Okay. Secondly, in your affidavit, normally you just reference to trucks coming and going, but in this particular case, you've identified 4 different trucks belonging to Eddie Huggins. Were you able to make a positive identification of these trucks were hauling for one of the mine owners?
Yes, they all had Eddie Huggins on the side of the trucks.
Okay. Thank you. That's all I have, Madam Chair.
Any further questions?
Mr. Day, it appears that the tops are up. Are they open or carrying load?
I'm not 100% sure if they actually had loads in them at that time.
Thank you.
Could I ask a couple of questions?
We're listening to staff first, and if we decide to come back and open this up, certainly you can.
Okay. Well, for purposes of the record, quasi-judicial procedure would allow us the right to confront our accusers.
I certainly understand that.
Including cross-examination, so I'd like to note that. Thank you.
Right.
Let me just say, staff has no objection to the attorney's questioning Ms. Zedek. We did speak with Mr. Smith, who's associated with the mine. He gave an explanation as to why specifically the trucks that we observed at that time were heading south and coming from the south versus the majority of the trucks that were observed that were on the approved haul route. I can explain to you essentially what I was advised, and he's here to speak.
Why don't you let them speak for themselves?
Okay.
Thank you, Roland. I really do appreciate that. Madam Chair, I'm permitted to speak?
Yes.
Thank you.
If you'll identify yourself.
I did take the oath. Yes, ma'am. My name is Steve Smith. I am the owner of Rancho Lake Sand Mine. Eddie Huggins Trucking runs the sand mine. We have our own ticket taker that's a booth right at the front of the sand mine that works for me, that collects tickets. I'll get straight to the point. The trucks that Ms. Zedek approved did come out of our pit. They did come up State Road 60. They were reporting for duty. They'd been sent up from Stewart that morning. It was their day 11 and day 14 driving a dump truck for Eddie Huggins. We've got payroll records, which I shared with your staff, which I can't make part of the public records as Social Security numbers, etc. But I've shown all of this to your staff yesterday to document this. Day 11 and day 14 on the job, driving a dump truck for Eddie Huggins. This was their very first day driving in Vero Beach. They were sent up from Stewart. They did come up the wrong way on 60, but they were not in the haul route at that time. They were just showing up for duty. They did go into our mine. They got filled up with dirt. They did accidentally leave and go the wrong direction. We don't dispute that. But what we do come before you here today is to say 2 trucks, brand new drivers, first day on the job in Vero Beach, very first run of the day. The Eddie Huggins supervisor, our ticket taker, so to answer your question, Mr. O'Brien, Commissioner O'Brien, our ticket taker monitors that. They all know. They get told 15 times a day, don't speed. They get told 8 million times, you can't go the other direction. These guys accidentally, the very first time they ever left our pit, went the wrong way. My ticket taker called their supervisor, said, hey, 94 and 70, the truck numbers, they were following each other, as your picture shows. They went the wrong way. Called them on the radio, said, hey, I won't use the language that was used, you guys blew it, you screwed up, turn around, go, when you come back, go the other way. The rest of the day, they went the correct way. Even on your report here, 2 trips that were hauling out of 2 trips out of 47. What's that? 95, 96% success rate out of my pit. Now, I'm not talking about the other one, because the other sand mine is a different issue. Their situation they have to deal with on their own. The pictures in the newspaper on Saturday, that was not a truck out of my sand mine. And I can document that with proof if you'd like. We are extremely diligent out of my sand mine. And I know you guys are inundated with phone calls by a few people that live out there. And I'm not going to call any staff out by name, but I've even been told that they have documented times where they've gotten phone calls and it's citrus trucks flying up and down the road. But they're calling and blaming us and blaming Tom Hammond. It's a little bit unfair that we're being painted with this broad brush. Now, again, 2 guys, first day on the job, first run of the day. If you want to shut my business down, because that's what this is, if you revoke the bond, you pull my permit. I've got 500 people that depend on this mine staying open. It's not just pull the bond and come back next week. You got 500 people, from the truck drivers to the people that work at their offices to the people at the sites where the dirt goes to. All our dirt is local in this county. So you got 500 people that are making 10, 20 bucks an hour that are going to lose their jobs or not get paid for a month by the time we have another hearing, and a bond gets approved again by the city attorney or county attorney. We're out of business for a month. Think about that. These are guys making 10, 20 bucks an hour. To shut me down because 2 guys made a legitimate mistake that was immediately corrected and remedied. You can have code enforcement sit out there 40 hours a week and watch my pit. I guarantee you, I'm the one running a grader, I'm the one running a water truck, and I'm the one making sure my guys go the correct way. So to shut me down it's unconscionable. And I won't even, I have to at least bring it up. I mean, Habitat for Humanity started hauling this past week out of my pit. Mike from Cathco that's doing the job is here. We bid that job at cost. I'm not making 1 penny on the dirt to Habitat for Humanity. They need 50,000 yards of dirt. if you shut me down, Habitat now has to go buy that dirt, and he'll attest to it, $150,000 if he's got to go buy it out of the county now and get paid retail prices and truck it 20 miles farther. So if you want to have 500 people and Habitat for Humanity all get basically thrown down the gutter because of two guys making a legitimate mistake, I mean, I'm pleading for some reasonableness here. The sand mining stuff, it's gotten way too hot of a topic. It's become a political topic.
Let's really stick to what we're discussing.
I am, but you also need to understand the ramifications of crucifying us because of two guys
let's don't
making
use words
legitimate
like that, please.
Yes, ma'am.
Thank you. Any questions?
Just the Eddie Huggins, they're based out of Stewart.
Yes, sir. And
Were all their drivers based out of Stewart?
Yes, sir. He's here too. If you need to ask him anything, he'd be more than happy to answer your questions as well.
Okay.
They're not all based out of Stewart. Some of them are based out of Enviro and then live in Fellsmere.
Okay. When you hire these new drivers, do they go through an orientation? Do you explain to them what haul routes are? And
Yeah, normally what happens is every morning before any of the drivers leave or shop in the morning, they get a map, and on the map it's highlighted exactly which way to go to the job, which way to come from the job. These two drivers normally always work in Stewart because they're from Stewart, and that particular day, the first load of the day, they left out of the yard around 6:30. They went to the job they were supposed to go to with their maps, and it got canceled like around 7. So instead of sending them home, they were dispatched over the radio to go up to the sand mine and get loaded, and they were explained over the radio how to get there. Well, they got lost, and so that's why they came to the job the wrong way, and they left the wrong way. And just right as they were leaving the wrong way is when everyone's seen that they were leaving the wrong way. Once they got to the job, the other drivers got with them, told them exactly how to go, and from that forward on, they were fine. So that's kind of how that day went.
Okay. All right, thank you.
Any other questions? Staff, do you have any more to present to us?
I have one question to staff.
Okay.
The evidence or the information that was presented to you by Mr. Smith, did you look at that and verify it?
I'm Bob Keating. I'm Community Development Director. Yesterday, Roland and I met with Mr. Smith, and yes, he did show us some payroll records. He showed us some dispatching records. He showed by truck the times that the truck left the mine. And from what we can tell, we don't dispute what Mr. Smith says. What we're reporting to you is what we actually observed in the field.
Thank you.
Any further questions? Thank you. Staff, any further presentation?
Madam Chairman, I would just note that Mr. O'Neill did say that they waive any future appeal, and he may have something further to say, but I'd just like to note that if this is the appeal that he's waived in the future, it provides that the board may, upon findings of fact, determine that the violation did not occur or was insignificant. I think the testimony from both the staff and Mr. Smith was that the violation did occur. The finding that you would have to make in order to uphold their appeal was that the violation was insignificant and that it amounted to 4 out of the 49 trips, or about 8%, observed during that period of time. And you certainly can take the circumstances that Mr. Smith and Mr. Huggins presented to you as extenuating to make a determination that it was insignificant. But Mr. O'Neill may have further comment if this is his only appeal. I'd like him to have that opportunity.
Well, I would like to ask the Commission your pleasure at this point. Would you like to consider this as the appeal, or would you like to not consider this as an appeal?
Madam Chair, I don't mind it being considered. If they're ready, I'm good. I've heard from Mr. Hammond's people that they weren't ready, but if they're ready, I don't have a problem with hearing at this point.
I have no objection. They've waived their right. They're here. They're prepared. They're represented. And Attorney Collins has also advised that it is appropriate upon approval.
Commissioner O'Brien?
I'm fine with that, but I think just to be clear, and Dot and I here, I'll go ahead and make a motion that the county voids whatever our requirement that the appeal is in writing, therefore allowing them to make the appeal now.
Madam Chair or Commissioner O'Brien, maybe the best thing to do is just let him write down he appeals, like he said, and let's go ahead and move forward.
Well, there's some more technical stuff of the appeal that's more detailed that I don't think he's prepared to do. I just think I'll make a motion now that we waive our requirement to require a written appeal.
Is that comfortable?
Yes, I'm fine with that.
I'll second that.
Okay.
Commissioner Wheeler, do you have any comment on this?
No, I'll hear the appeal.
Okay. That being the case, I will too, and we will now have it.
So the motion, Mr. O'Brien's motion to waive the written appeal passes.
Yes, and I'm not finished. And at this point, we will continue on with the hearing if this passes. All those in favor?
Aye.
Opposed? Thank you very much. So we have heard any further from staff.
Just to bring to your attention the amount of compliance bond we're speaking of. I didn't mention this earlier. It is in your backup, but the compliance bond is based on $1,000 per acre of the identified phase of the mining project. In this case, the Ranch Road Lake Sand Mine, that calculated to $51,490. The other mine was a different amount based on a different acreage identified for the phase. So the other mine was $18,000. This one is $51,490. Thank you.
Thank you. Would you like to present your case?
Thank you very much. Hate to be redundant because my client has already given you a good part of our defense, which staff doesn't seem to contest. Tying that to what Mr. Collins had to say, your standard, at least on appeal, which is where we're at now, is whether or not it's insignificant. And the numbers that have been bantered about using staff's own affidavit, 4 of 49, but 2 of the 4 were the 2 that were coming to the site when they were supposedly lost, but they weren't hauling. And what we've been charged with and what your ordinance is saying is when we fail to follow the haul route when we haul. Well, we weren't hauling. So I think you can throw that first 2 out the window, and you're down to 2 out of 49, and as my client said, that equates to 96%. I would respectfully suggest to you that it's insignificant. As a matter of fact, I'll be glad to put on evidence, but we have evidence that that week there were 733 runs all to the north, and so the 2 out of 733 is 1%. So again, it is very insignificant. You've heard the gist of our defense, that it was an error, mea culpa. In the law, we say it's de minimis. I explained that to a friend yesterday, and they said, it's what? And then he says, oh, you mean like picayune? And I said, yeah, that's what it means. And in your ordinance, you use the word insignificant. Folks, let the punishment fit the crime here. For 2 that went the wrong way, the 2 new drivers that messed up, you're going to jeopardize a $51,000 bond. And of course, that's just one of our bonds. We have 2 other bonds as collateral security for our performance. And if we're put out of business, it is very draconian for a mistake of 2 trucks. What I have, and my client alluded to the economic effect, and I would think as a board you'd probably want to know this, but if you're shutting us down for the 2 trucks, we've alluded to the Habitat for Humanity, which is going to cost them immediately $150,000 more. We have this doctrine in the law called unintended consequences. You've got a new school where there's people here that have bid on that. That if you shut down both mines, people have to go to St. Lucie County to get sand. The cost just on the school will be $250,000 more to taxpayers. I have people that can present that evidence, and I don't know if you just want my summary of that. but I'll be glad to call them. They're here to present it. There's a enterprise zone that's just starting near the Gifford area. The price is already in effect. You shut us down, that's going to raise that another $25,000 to $60,000. Some of the people that want to talk about the impact, I'll be glad to call them forward now if you would like, or if you've heard enough from me just on a summary. I don't want to beat a dead horse. Our position is simply that it was a mistake. It was insignificant, relatively speaking, and the punishment would be shocking in light of the crime.
Any questions? Thank you.
Okay, thank you.
But if you want to put on any more, be sure and do that, because I'm
All right.
in this process.
Mike from Cavco, could you come forward, please?
Madam Chair.
Yes.
As far as I'm concerned personally, I think the resulting consequences are irrelevant. I do believe that, staff has verified the evidence presented to them by Mr. Smith. And I think that we need to determine whether it was a violation and whether we think it was de minimis or not, and that ends it. I don't think that we need to hear, what's saving. And the reason I say that is because I find that if this is an error and the staff is verified, and it was a matter of 2 trucks, new drivers, then I think as was said, that this is insignificant as far as that goes. But the bottom line is I don't know that it's relevant to the question here as to who's getting sand and who's paying for it and how much it's going to cost.
But we want him to give up his full case if that's what he wants to do.
All right, I tell you what, let me just call on one aspect of the shutdown, and the other witnesses, unless they're dying to come forward, I'll just call on Mike and stop it there.
We don't want to tell you what to do either.
Thank you. Mike, speak up, state your name, and talk about what contractor relationships you have going in connection with this mine, if you would.
Mike Isaac from Cavco Construction, Vero Beach. We have we have many projects going on in this county. All our projects are here in the county. All our jobs are here in the county. They all come. Most of our material comes from the 2 mines right here on 82nd. We have contracts with Habitat. We have contracts with Indian River Industrial. That's the zoning, the new zoning on 41st Street. By these pits getting closed down, that's going to shut us down. That's going to put me in a conflict with these people I have contracts with. Now I have to go to them and say, okay, now I have to go out of Indian River County, give this business to people out of the county to support your supply of material to your job. And by doing that, that's just going to hurt them and us. And if they do shut this down and these people decide not to finish their projects, that puts me out of business. Now I'm going to be laying off people in this county because I depend on these pits to keep us going.
Do you have an opinion on what it would cost you just on your Habitat project? How much more if this mine was shut down?
Yes, if we have to go to this pit in St. Lucie County, we had a cost figure increase of $125,000 to $150,000. Just material and trucking being the cost we're getting the material here in town for compared to out-of-town prices.
And is my client selling you the materials at cost,
Yes, at cost.
Okay. That's all I have. Thank you.
Thank you.
I just have a question. So what you're saying is there's no other operating sand mines in Indian River County?
No, I'm not saying that. They're the only ones that have general fill in Indian River County that I know of right now.
All right, so no other sand mine operating in Indian River County has general fill?
Right. That I know of.
Any other questions? Thank you. Are you finished?
Yes, I am. Thank you very much for your patience.
Thank you. Any questions of our staff or of the opposition or our attorney? Have any further? May I have a motion?
Madam Chair, just looking at the affidavit from Ms. Zedek and counting up the numbers and not notwithstanding Mr. O'Neill's interpretation, if an empty truck is or is not using the haul route, I think if it's going to the mine, whether it's empty or full, it is using the haul route. So I count that as 4 trucks. But the previous mine, we had 13 out of 17 observed trucks going the wrong way, the unapproved way. And in this particular case, we have 4 out of 49 observed trucks going the wrong way. So in my mind, I think that does meet within our code the definition of insignificant, and therefore I move that we not approve the resolution revoking the compliance bond.
I'll second for discussion.
Discussion? We'll start at the other end. Commissioner Wheeler?
No, I would agree, and I think the fact that I'm comfortable with the fact that staff has verified what Mr. Smith has presented, and based on what Mr. Smith said, he is doing everything in compliance and has been and is very, very mindful of that. So I'm accepting him at face value, and also the fact that staff has verified that.
Commissioner Davis?
Yeah, no, ma'am, other than the fact that I had some conversations, and I don't know how far back I need to go about the conversations with individuals living in this district. It goes back to ever since the mine opened up, but, I mean, I've had conversations with...
I think all of us have.
So I don't know what I need to disclose. I talked to... I can do it in the past 3 days, or I can do it a year ago, but we'd be here all night. And so I just want to make sure that everybody knows that I have had conversations with individuals around this pit, whether they're from the Sextons on Sunday to Tom Hammond the other day. So I just want to disclose that I have had conversations with individuals, and I think I was supposed to do that as a quasi-judicial hearing.
Yes, Mr. Wheeler?
I'd like to say the same thing, and I think but the only conversation I've had is I've had one phone call, and I explained to them the procedure and that this would be coming on the agenda today. Yeah. But we did not discuss anything else to do with the mine other than what was on the agenda today, and that it would be on the agenda today. So I've had numerous conversations over the past year, but not since this violation.
Okay.
Commissioner?
I had a discussion with Mr. Smith the other day, and we discussed that we couldn't discuss. And the same conversation I had with the county administrator yesterday that we discussed that we couldn't discuss. So I just want to add, too, that, you know, we're dead serious about this haul route, guys, okay? It's been widely reported in the papers the last couple of months. You guys need, you know, to dot every I, cross every T. We are dead serious about enforcing this, okay? Just no more ifs, ands, or buts. No more golly gee whizzes. Mr. Smith, I'm very glad to hear you're the guy running the grader and the water truck, because I will know exactly who to call when that complaint comes up. So hope you got your commercial license ready to go and everything else. But we are real serious about this, guys. No doubts. All right.
Commissioner Fletcher?
Madam Chair, I just want to advise that I've had no conversation about the mining at all, but I do have some past recollections of when I was in another element, specifically in law enforcement, with the operator of the Huggins trucking. And it was when we were developing a large distribution center west of town concurrently with a mining operation, and the Huggins trucking company was reported to be the violator, and of course I responded. And this fine young man had recalled all the drivers and had them noticed and had a roll call, and I truly appreciate their responsiveness, and I accept the understanding and the information, and I hope that concurs with Ms. Zidek's findings as well as her observations, and that's why I was trying to point out whether they were loaded or unloaded, just to determine if this was fact an oversight, and it does appear that it was an oversight and corrected very quickly, and I appreciate that.
Let me just add one point that's in the ordinance. When it talks about an appeal and a board finding of the violation not occurring or was insignificant, it further says the board may return all or part of the compliance bond. So there is an opportunity for the board to consider partial collection on the compliance bond. It's just a point of information.
Thank you. I do agree with the commissioners that this was somewhat minimal, but I also agree that we will be out there again continuously, and hopefully educating your drivers and the process, the road, maps, whatever they need. Take them out there and drive it yourself with them. We don't want this to happen again. Please. Severe consequences.
So it can be anticipated that there'll be other 6 a.m. shifts performed?
Whatever's necessary, we'll do. Do we want to...
A motion for that, or did we?
There is a motion to
yes.
not approve the resolution. I don't know if there was a second or not.
There was a second. I seconded,
We're
sir.
under discussion. Any further discussion or questions? All those in favor?
Aye.
Opposed? Passes 5-0. We'll take a 10-minute break for captioning. We can call the meeting back to order, please.
I don't know. Anyway, he's doing all right now. We thought.
Number two. Yes. We could call the meeting back to order, please. Thank you very much. Commissioner O'Brien.
Yes, before we proceed to the next item, just a quick follow-up. I think we verbally expressed it that we want to make sure the mine operators are on notice, but I'd just like to make a formal motion to instruct the county administrator to continue to take any and all actions to ensure that we are making sure these mines are in compliance, and if that means additional code enforcement activity, whatever, I'd just like to give formal direction to the county administrator to continue with that.
I'll second that.
For discussion. I'm not sure we need that. I think he got the message loud and clear, but it's always good to have it in writing.
We'll be monitoring for everything, road conditions, dust, traffic going the right way. We will do that. We'll make sure.
Could you please repeat the
just a motion to direct the county administrator to continue code enforcement and monitoring any and all violations of the hauling permits for the mines.
And we had a second. I do see someone in the audience that would like to speak. I usually don't open it up, but I will at this point.
Thank you, Madam Chairman. My name is Suzanne Fransky, and I'm at 8190 37th Street. I just would like to put it on record that the trucks were running southbound yesterday. And we didn't get an opportunity to share any of that, but they were running southbound yesterday. Thank you.
Thank you.
Well, I think we have a motion now to make sure that we monitor this, if necessary, 24 hours a day.
Whatever the administrator
Whatever is necessary. Yes,
I'd just like to say, based on Ms. Fronsky's comments, if they're running south tomorrow, we know which mine they're from, because the other one will be operating. So hopefully there'll be no southbound trucks tomorrow.
But we'll know that for sure.
Yes.
Through staff.
Yeah, and if she'll call right away, we'll try and get someone out there as quickly as possible and verify it. That's what we need to do. And that's how, because of Mrs. Fronsky's complaints, that's why we got more aggressive, and that's how we caught the ones that we caught the other day. And we're going to continue to have that kind of that kind of monitoring out there.
Thank you very much. All in favor?
Aye.
Opposed? Passes 5-0.
Thank you, Madam Chair.
2, consideration of establishing a process for revising county mining regulations. Memorandum dated January 8th, 08, 152 to 155. Staff?
Good morning. I'm Stan Bowling, County Planning Director. Last week, the board enacted a moratorium on processing or accepting applications for new mining operations. And as part of that item last week, you all directed staff to come back to you with an outline of a process of, during the moratorium period, how are we actually going to go about revisiting the mining regulations and drafting them and getting them in a form that can be formally considered. There obviously is going to be a lot of research that's needed, public input, expert input, and drafting of the regulations. And there's some big picture type of decisions for you all to make. Staff has outlined a process for you all to consider this morning, and I'd like to spend just a minute explaining it. One of the first items for you all to consider is who will manage the process during the moratorium period of revisiting the regulations. Regardless of what you all decide with respect to that, staff will be very much involved, obviously, in anything that's done. We see 3 basic options for you all to consider. One is what we would call a staff-managed process. We could go through a conventional process with our existing committees and public meetings before them, but staff would essentially run any workshop meetings that were to be held. Another possibility is to use an existing committee. 3 come to mind as far as staff is concerned. The Ag Advisory Committee has looked at some mining issues before. The Professional Services Advisory Committee looks at all land development regulations. And the Planning and Zoning Commission. They've looked at a lot of different regulations, and they've held workshops in the past as well. You also have to consider public participation. Do you want to go above and beyond normal hearings and have workshops? And then the other aspect to consider is expertise. You've got expertise on staff, but you could also bring in experts from the outside. You may be able to use some experts, piggyback on existing contracts with consultants, or you may decide that you want to hire a consultant, especially for this task, for the overall task. Staff has looked at all these items, and this is essentially what we're proposing. First, cognizant of the time frames, a 6-month moratorium that could be extended up to a maximum of 12 months. Staff is recommending that you all use an existing committee to essentially hold a series of workshops and report back to you. And our recommendation is that you direct the Planning and Zoning Commission to do that, since they deal with a broad spectrum of issues. There's a balancing of interests that's needed, and they're existing. They're already up and running and have run workshops before. Staff would be assisting, again, whatever route you all decide to take. We'd be involved very much in, I think, the researching and discussions and setting up things and logistics and so forth. We would recommend that there are two kind of first orders of business. One would be for staff to prepare background information for you all, for the Planning and Zoning Commission, post this information on the website, and then to conduct a mobile workshop of the Board of County Commissioners and the Planning and Zoning Commission, if that's who you choose, to actually take a look at some existing mining operations, I think both in the county and out of county as well. And then hold a series of public workshops. And if you all direct that the P&Z is kind of the manager of this process, we see 4 areas that we think 4 different workshops need to be held, and that would allow for public input as well as inviting experts. We think there are experts that can be brought in. There's a lot of expertise that's being developed right now around the state, because as you all know, this issue is a hot topic and has been a hot topic for a while around the state. We don't believe that you need to hire a consultant, go through that whole process to manage the whole process. We think that you can use any of the options that we've just kind of outlined and summarized. We also think that a key component is, as we get started, as we go through this process, about 4 months from now, 4 months into the moratorium, staff will report back to you all. I think you'll be aware of how things are going anyway, but report back to you all the status, so that if the moratorium needs to be extended, you all will have a 2-month period to do that and to take that into consideration. So staff's recommendation is to use the P&Z, conduct a series of workshops, allow staff to perform duties we need to for kind of an information and orientation phase. For the P&Z, again, if you also choose to come back with a set of at least proposed regulations, and then to go through the formal process from there. And that's staff's recommendation. I'd be glad to answer any questions that you might have.
Any questions of staff? Commissioner O'Brien?
Just Stan, have you spoken to any of the P&Z members, if they're willing to, do they have the time? I understand your point about their expertise and experience, and I agree with all that, but just from a time standpoint, these are kind of volunteers, and how have we talked to them, and how do they feel about it?
There was a Planning and Zoning Commission meeting last Thursday evening, and I did bring up to the P&Z that we volunteered them for this effort, and they did not mutiny at that time. I think they do acknowledge that it's going to be a lot of work and a lot of effort, but I do think that they also acknowledge that it's probably one of their responsibilities.
Commissioner Fletcher?
Well, I share the same concern. Many of them are business owners, operators, and have full-time jobs, and it is difficult enough to ensure that they attend the evening meetings. There's an awful lot of research involved with P&Z, and I think that this might be much of a task in order to call upon P&Z and have them continue on during a 6-month moratorium, where we're seeking to have this all resolved in short order.
Commissioner Davis?
I know my appointments are up to the task.
Commissioner Wheeler?
I'd ditto that.
I think that certainly they would volunteer to do the job. It might be somewhat of a task of yours, but I'm sure you're up to the job to coordinate their schedules because P&Z is evening. This might be a combination of evening, daytime, maybe some field trips. I don't know. Whatever's necessary we need to do to completely educate ourselves and bring in experts.
And actually, that's an excellent point. What we were looking at, we're waiting till we got your direction today, and if you do tell us that you agree with our proposals, we're going to develop a detailed work plan. We're going to have a lot of targets in there for workshop meetings, and as you indicated, it'll probably be a combination of daytime and evening meetings. But we're going to really nail things down, be real specific, and just itemize every step in the process, and we'll be doing that real soon.
The one thing that I'd like to make sure of is to maximize, and not necessarily the time of day, but maximize the public input. We've got a lot of property owners that may be affected by this, especially if we start messing with anything in the A1 zoning. I mean a lot of property owners, as well as we've got a lot of property owners that are currently affected by what we have in place. And so I just think that plenty of input and plenty of opportunities is going to be very important in this for everybody to buy into the process.
Yeah, and as Stan said, we will be either setting up a separate website connected to the counties or extensively using the county's website, so the public is going to be able to acquire any information they need regarding meetings that will be held or reports that are due from the website, and we'll publish that.
I do think because we have not at this point began republishing our agenda, I do think we ought to take out some ads and include the public in our plan when we get it all together.
And the municipalities, yeah.
Yes.
Make sure that, this is big.
The largest one?
Yes.
Geographic or?
Geographic.
No. I figured that's what you meant. I just wanted to clarify.
Good morning. I'm Joseph Paladin. I'm the president of Black Swan Consulting and Entitlement. I have a couple of brief comments. I agree with everything that staff said, and I don't think we should hire a consultant. I think that would be a waste of money. I said, but the problem I have is using the P&Z Commission to do this process. I thought that would be a better idea to get a fresh set of eyes and thoughts on this, and for the commission to appoint a committee similar to like what we did to review the impact fees. Have them appoint a committee, have staff chair it and be a part of it, and then we need to bring this back to P&Z. P&Z is actually going to be voting on a lot of this stuff and a lot of things that come out of these new LDRs. And they've already had an input with the LDRs we have. So I think if we all appointed someone and had staff be a part of that committee and chair it and run it, and then have some outside experts on the committee, I think we'd get a whole lot more input, and we'd be able to bring something back to P&Z instead of having them part of it to start with. I think we need to appoint a new committee. And I think we have the time. We have plenty of time here. We're going through a 6-month moratorium, and we need a little more time. We need a little more time. But I think we want to come back with a real finished product and get all the input from experts that we possibly can. So that's what I would suggest.
Madam Chairman?
Yes.
Mr. Paladin, I don't mind what you're saying, but I think that it's very important for our planning and zoning staff to understand why we have the LDRs that we have whenever they get ready to make the decision, and then to be able to question those LDRs to shape them so that there's something that they feel comfortable with. I'm not precluding the group that you're wanting to perhaps be a part of this. I encourage that. I wouldn't mind if you had an industry representative, and if we had a neighbor representative group, and let them come forward and say, listen, this is what we have to have, or since we're using Latin, this is a sine qua non in this process.
And I wasn't suggesting that I be on the committee. I wasn't suggesting that I be on the committee. I would suggest that each one of you county commissioners appointed someone that you felt had expertise in that area to the commission or to the committee, and have somebody from staff on the committee, and then some outside special experts that maybe would be on the committee. I think we get a lot more input. I understand that the P&Z Commission has expertise in our LDRs and the way they put the LDRs together, but we're looking at water. We're looking at things that require more expertise than just putting together a written LDR. I think we get a lot more input from bringing people in on this committee that could give it their full time and then bring this product to P&Z. And then P&Z would also have their input. I just think we get a better product by putting a committee together than having P&Z from the very beginning. Because don't forget, they've already been involved in this process a couple of times. That they've had a lot to do and a lot to say about the LDRs we have in place that you all want to relook at. So I think we have more to gain by appointing a committee.
Yes. Name and address, please.
Yes, Commissioner, thank you for letting me speak. Robert Adair, Chairman, Agricultural Advisory Committee. I'd like to add my 2 cents, take it as it is. I think that staff is giving you a great way to proceed with this. I wanted to maybe ask for your consideration that possibly the Agricultural Advisory Committee be allowed a venue with P&Z. I mean, typically right now we would advise the county commission. So in this process to sort of take advantage of existing committees that we already have in place in the county to get accurate information and concerns from the different industries, if the Agricultural Advisory Committee could have direct input into the P&Z during this process, I think you could accomplish what Mr. Paladin's suggesting. However, it would be using your existing committees, and possibly you could use maybe your Land Acquisition Committee to have input, and your Conservation Lands Advisory Committee, and what other committees you see fit. But remember, the pathway now is to the BCC. I'm suggesting that during this particular process with mining, that there would be a venue for these existing committees to have access to P&Z.
Madam Chair?
Yes.
Bob's asking for the same thing Joe's asking, just for a different group of people. And I think that as this comes forward, Bob, I think that independently as an Ag Advisory Committee, I think we're heading in that direction that you're talking about and making a recommendation as the Ag Advisory Committee and that venue. I think that Mr. Paladin, is going to be incumbent upon you or concerned individuals to, if you've got an industry concern, you're going to have to come forward with those in this process and be a part of it, just like the Ag Advisory Committee is. They might have a little more structure at first, but I believe you can get caught up, because I've certainly seen the residents get brought up to speed in a hurry whenever there's issues that are affecting them. We still have to have one group that's going to be a clearinghouse, one group that we as a commission need to be able to say, okay, this is where we're going to spend our resources, our tax dollars with staff to be able to craft the policy. Now, that doesn't mean that, the Ag Advisory Committee won't be able to make the recommendations for the citizens of the industry, or the neighbors won't be able to give their input. I mean, we're getting it all the time. But we've got to start somewhere, and we've got to start somewhere far enough, I'm going to say, down the chain from the citizens, all come down the chain to where the commission is, so we can narrow down the ideas and craft some wise policy.
I wouldn't object to having a workshop or a venue to include these three plus an organization. What is the one you're ahead of?
And I wouldn't have a problem with what you just said either, but a counterpoint to that would be, if you wanted to have a member from the various committees which we're trying to decide on be a part of this committee that we're going to put together, then they could report back to their various committees at their P&Z meetings and keep them informed as we went through this process until the 4-month period's up. I just think having some new people come in here that actually have some expertise in that area, as far as water supply, as far as traffic or whatever the problems are, I think you're better off than just keeping a committee that you already have put together. So maybe you save a couple of weeks by appointing a committee. I think you're going to get a whole lot more new information from new people, but I would keep those committees involved as maybe members of that new committee.
But what is it that's making you think that we would not do what you're talking about, though, by using P&Z as the focal point for this ordinance?
Because I think a finished product would be brought back by this individual committee that you all would appoint, and bring back a product to P&Z that they would look at as the P&Z. I think P&Z, looking at a product that they put together, I'm not getting the same objective look. I'd like to have P&Z look at a product we brought to them, much like you appoint a committee to bring information back to you. And I think P&Z has expertise in LDR writing, certainly in reading laws, and certainly in deciphering laws and different things. But you can't tell me that everybody on P&Z has expertise in the problems that we have. And I think when you all appoint your person that you would like to see on that committee, like Mr. Adair, he'd be a perfect person on the committee. You appoint somebody that has something to offer other than just being able to read an LDR and see it is written properly, and have staff chair the committee and run the meetings. I'm fine with that. But I think you need to get these experts in on this committee as we form the LDRs, see what the repercussions are. Sort of like, you know, if you have, when we did the LDRs on some of our buffer changes and things like that, if we didn't have engineers and developers on the committee to say, well, no, that don't work. No, we can get around that and give you the inside look on how we work on that. You wouldn't have got the finished product that you got. You know, that finished product came out rather well. So I would ask you to please consider that.
Thank you. Anybody else like to speak to this?
Good morning, Ralph Evans, 1420 Shorelands Drive West. I just want to make something clear to you that Mr. Paladin is not speaking on behalf of the Wild Turkey Mine, nor am I. But it did occur to me when we were having this conversation about what should be the committee. And the point is well made that this is a hot topic around the state. And in fact, the governor did appoint a task force that was a select group of folks. My only comment about that would be maybe that's a good idea. No offense to P&Z, no offense to staff for recommending them. But in fact, it is a hot topic, and there are a lot of things to discuss about mining, whether it's dewatering or traffic and those kinds of things. And maybe a committee that's dedicated to one purpose as opposed to P&Z that has a realm of responsibility every Thursday night or every other one. So I would chime in with Joe on that issue. I think maybe it's a better idea to have a select committee, regardless of how you get to it, that is committed to the mining, the revamp of the mining ordinances. Thank you.
Thank you. Anybody else want to weigh in on this? Yes.
Madam Chairman, Commissioners, my name is Gary Smith. I live at 6625 West 82nd Avenue. The only point I want to make on this is that I feel myself comfortable. I think planning and zoning is appointed by our elected officials. I believe in government. I believe in our county government in that fact. I believe that planning and zoning, when they make decisions, we use our county staff who are hired, who's hired by our administrators and by our who's also run by our commission. I feel that when we start getting outside help, and who are the experts? I mean, we have the experts. If you want to play this thing how it comes out side by side, is the experts over here or the experts over here? I think the county, as the planning and zoning, and the commissioners should decide who should be on the committees. I think we're on the right track as far as involving the people who do elect the officials in the county, involving the county's experts, or the county's, they can decide who the experts are, hire consultants, or what do they have to do. Thank you.
Thank you. Anyone else? I do want to point out that on the P&C we have 7 members, 5 appointed by us and 2 at-large members, so we do have the public represented there. If you want to enlarge the P&Z for this, we could consider that if you wanted to appoint a new one. But I really think that staff pretty much has put a lot of thought process into this. Would like to include the other 2, venue for the other 2, and of course the public.
Yeah, that's, and I guess really, Bob, how would you, without going through, and I don't mean this in the bed, we don't anybody take it wrong, but without going through the charrette process, but getting down to the point where we could have some meaningful dialogue and some policy improvement. I understand what you're saying about how we could do that at the P&Z level, but at the same time, I can assure you that Gary Smith is an expert on how traffic affects a resident in a neighborhood where a mine is. And I know he'll take the time to be here. But I don't mean this in a bad way, but, P&Z understands that too, but they're kind of looking at times perhaps over some of the small, I don't want to make it like it's a smaller issue, but they're trying to look at a broader picture, I suppose, than a neighbor's backyard, or a broader picture than a developer's interest. How do we, without going through the charrette process and going through the P&Z method, how do you suggest we flavor this discussion with that?
I think through the process, we want to invite the residents who know traffic and Deputy Smith who knows traffic, as well as a lot of other experts. I think and I'm not sure the actual forum or procedure for holding workshops and actually the logistics would really change if you had a task force or if you had the P&Z. Actually, a task force is not a bad idea. The challenge, I think, is getting balance on it.
Right.
That you have really, if there are two sides or more than two sides, that you have them all equally represented. One of the parts of our thought mechanism going through was the P&Z is kind of disinterested in this issue, in the sense that they really don't have a dog in this fight. So in that sense, they can really, I think, sit back and be objective and kind of manage the process and let the experts come and provide the information. And particularly through staff, I'm anticipating that we're going to write issue papers, and based on issue papers and information we get from the state task force and from experts, and actually having experts at the workshop or workshops, we'll actually be able to develop criteria and come up with specific LDR wording. And I don't know whether that answers your question.
Well, yeah, it kind of confirms what I was saying, though. I think that they're going to, not that they would, but it would give the appearance the P&Z is going to look over the hot issues. And the hot issues being the traffic in somebody's backyard, or the hot issues being somebody's ability to be able to mine aggregate on their property. And I think by us not, I don't know, rolling up our sleeves and going straight to the dirt. I mean, of the issue, we're really missing an opportunity here. And I don't know how to do that without. I just feel like the P&Z is going to be one step removed. But I understand what you're saying. It's a good focal point for us to bring it all together. So I don't know. Maybe we should have just this group get together with their presentation, the Ag Advisory Committee get together with their presentation, the industry get theirs, and then everybody bring them together in front of P&Z at the same time.
And just to add to what Bob was saying, I think maybe the workshops can work that way. Scheduling. That's why we have different topic areas. I would definitely believe that either the Ag Advisory Committee or some of the information they're seeking would be presented at a workshop on environmental issues, and we may need more than one workshop on environmental issues. And you may have Dr. Bacchus, you may have other hydrologists as well, and scheduling presentations, before the same committee. But the workshops are where the sleeves will be rolled up, and we would schedule different people giving presentations, and it may be presentations from members of different committees. That would certainly be the place to do it.
I guess as long as we can do that, I really do. I want industry, I want neighbors, as well as our other advisory committees involved in that. And I'm almost concerned that we're getting so big and trying to represent so much that we're going to be, I don't know, top heavy and cumbersome. But I guess we got to start somewhere.
Commissioner O'Brien?
Just, Will, if I can just reconfirm with you, this is a legislative matter, so we are free to talk, other than the other commissioners, we're free to talk with residents, mine operators, staff. There's no restriction on who we can talk about the proposed LDRs. Is that correct?
You're correct, including what you said about not talking to each other about this until it comes to a public meeting.
Correct. Okay. So
you can talk to anyone else.
So I think one thing, Commissioner Davis, is, I have a monthly meeting down in Bureau Highlands, and this will certainly be one thing I'll keep bringing up to them. Any comments, bring them to your commissioner, bring them to me. So I think we'll get some of the backyard comments that way as well, without having to form another committee that we got to take minutes on. And
yes,
I'm John Sanders at 2146 20th Avenue. Is the DOT decision in February going to change the way this committee might look at things?
I don't want to speak for the committee.
Yeah.
But
Well, there's not a DOT decision. There's a task force that was appointed by the governor. They're supposed to make a report, I think, to the legislature February 1st, and we'll certainly be on top of that and make it available to whatever groups are involved in this discussion.
All right.
Any other questions? One of the things, bringing up the sunshine situation, or a new committee, or this, that, and the other, the more we enlarge the committee, the less effective I think it will be because of the sunshine law, and would like to keep it probably P&Z, but everybody's input. Then you can talk to each other. Yes.
The only thing I'd like to add, and the webpage and so on and so forth, and interested parties, I'd like to see a place where anybody interested in this county-wide could sign up and give you either a snail mail or an email address, and all of them be notified of each and every workshop and meeting that comes up. So it's not up to just having an ad in the paper where they may or may not see it, but they'll either get an email that they can acknowledge or snail mail so they know where the meetings are and they can show up and give their input.
That's a good idea. Any other ideas like that should be submitted to staff, and I'm sure they will try to accommodate everyone as we move forward on this. Do I have a motion?
Second.
You're moving staff recommendation?
Staff recommendation with what we discussed.
Anything else?
Madam Chair, I do agree with staff, specifically with Stan Boland's recommendation that the P&Z would be the best suited entity to do this. I do encourage the committee involvement, all of the committees that have any latitude to bring forward information, and I trust that will be the best avenue. My concern about initiating a new committee would be lengthening the process, and the fact that the committee was established after we've had this tremendous challenge, and P&Z does have the tools necessary, and I do trust that if it is a burden, they'll let us know.
Yeah. Thanks.
Okay. All those in favor?
Aye.
Aye.
Opposed? Passes 5-0. Thank you very much. Public Works, Heritage Reserve Developers Agreement for Development Contributions to Roadway and Intersection Improvements. Memorandum dated January 8th, 2008, 156 to 177.
Thank you, Madam Chair and Commissioners. My name is Chris Mora. I'm the Assistant Public Works Director for the county. This is a developer's agreement for Heritage Reserve. The developer of Heritage Reserve, Sandler at Pinecrest, LLC, has indicated a willingness to move forward with their project. It is a 780-home, 333-acre residential subdivision, again known as Heritage Reserve. This is formerly on the property formerly known as Dodger Pines Golf Course and Country Club. It's on the north side of 26th Street between 58th Avenue and 43rd Avenue, and it is totally contained within the city limits of Vero Beach. They have gone through the city site plan review and approval process, and because we share building departments with the city and handle concurrency for them, they submitted a traffic impact study to the county. We've reviewed and approved that. As part of their project, to handle their project traffic, they will need to build several intersection improvement projects, as well as contribute to several intersection improvement projects being done by the county. These projects, there's 10 listed in Exhibit A on page 168 of your packet, and there's also 4 additional partially funded projects listed on page 169 of your backup. The reason they're coming forward is if you look at Chapter 910 of our land development regulations, there are 2 ways that a development can obtain vesting rights. They can, if they don't come forward and apply for a building permit. And those 2 ways are they can enter into a proportionate share agreement and pay their share of roadway improvements, or they can enter into a developer's agreement, which is what is before you, in which they agree to construct a major capacity producing improvement. In this case, Heritage Reserve is proposing to widen 26th Street from 2 lanes to 4 lanes along their frontage, which is between 58th Avenue and 43rd Avenue. They would take the plans for the 4-laning from the existing 30% plans, which the county would prepare, and then they would take those plans on through to 100% and go ahead and build the 4-laning. They would receive traffic impact fee credits for any costs associated with that widening, including any permitting costs, design costs, right-of-way acquisition costs, and construction costs. But the agreement is pretty much a standard agreement as far as it's based on their project's share of traffic on these intersection improvement projects that are listed in Exhibits A and B. They would be actually contributing $1,280,000 towards the 4 partially funded projects in Exhibit B, which are all major projects being undertaken by the county. And as I mentioned, they would also be doing the 4-laning of 26th Street between 58th and 43rd Avenue. The Public Works Department has reviewed the agreement. The County Attorney's Office has reviewed the agreement, and we're all pretty much on board with it. We, as staff, are recommending that the board take it and approve the developer's agreement so that they can go ahead and proceed and obtain concurrency.
Thank you. Any questions of staff? O'Brien?
Chris, on 26th Street, is the developer required for the right-of-way acquisition as well?
There are several parcels that will need to be acquired for the widening. They would be in charge of getting that right-of-way. If a parcel were to need to be obtained through eminent domain, in other words, if there was not a willing seller, then the county would have to step in and get that through eminent domain.
Okay, but what about the actual cost to buy the right-of-way? Who's responsible for that?
Yes, there are several parcels that we would need to obtain from Heritage Reserve that they own, and we've got an agreed-upon price of $50,000 an acre that's written into the agreement to purchase the 3+ acres that we need from Heritage Reserve.
Okay, what about additional right-of-way on 26th Street?
They would need to coordinate the acquisition of that right-of-way. And as I said, if it should go through to eminent domain, then the county would step in and assist.
Okay, I understand the process, but who's going to pay for it?
They would pay for it initially and then turn those expenses to the county, and we would reimburse them.
Okay, so then we're going to have to buy the right-of-way.
That's correct.
Okay. And the only reason we need the right-of-way is because of this particular project?
No, sir.
No, this is right-of-way for the ultimate 4-lane widening of 26th Street.
Okay. Is that already in our long-range plan?
That's correct.
Is that in our capital improvement element?
Yes, we would be building it eventually. It's just that the developer, in order to receive their 7-year vesting, has stepped up and agreed to build it for us in advance of us building it in our 5-year plan.
And what is he getting for that?
I'm sorry?
Is the developer receiving any rewards for that?
He would receive traffic impact fee credits for building 26th Street.
And the ability to vest for 7 years.
That's what he receives in return for building it early, yes.
Yes.
Yeah, have they, on 26, has there been any determination, potential determination, I guess, made on whether or not they're going to culvert or whether they're going to purchase right away?
Well, obviously, because there's a canal on the south side, there will be instances where in order to maintain clear zone distance for traffic, we'll have to culvert portions of it. We're still looking at different alignments. As I said, but when we get the plans, the county is going to bring the plans to 30%, in which case we'll have the alignment pretty much nailed down as far as how much of the culvert would need to, how much of the canal would need to be culverted and how much would not. But we're not really at that point yet where we can say it's going to be 30% culverted or 50%.
Okay.
Any further questions of staff? Anyone in the public? All right, a pleasure. I'll take a motion.
Madam Chairman, I move to approve staff recommendation.
Second.
Any further discussion? All those in favor?
Aye.
Aye.
Passes 5-0. Thank you very much. State Road 60 between 82nd Avenue and 66th Avenue, joint participation agreement with the Florida Department of Transportation to advance funds for widening State Road 60 from 4 lanes to 6 lanes. Memorandum dated January 7, 2008, pages 178 to 191.
Thank you, Madam Chair. This is the State Road 60 widening project between 82nd Avenue and 66th Avenue, a joint participation agreement with the Florida Department of Transportation. To give you a little background on this issue, State Road 60 between I-95 and 66th Avenue is currently over capacity or very close to capacity, and it has to be widened between from the existing 4-lane cross section to a 6-lane section. In March of last year, the Board of County Commissioners agreed to go ahead and advance fund the 6th laning of State Road 60. In other words, give the money to the DOT early in order to achieve the 6th laning in 2 segments. Segment 1 is the 2 miles between 82nd Avenue and 66th Avenue. That's the agreement that's before you today. And then ultimately in segment 2 also the 1.5 miles of 6 laning between I-95 and 82nd Avenue. This locally funded agreement, which is another word for a joint participation agreement, for segment 1, the 82nd to 66th Avenue section, is the first of 2 JPAs to be considered by the board. The second segment will be considered probably later this year in October. This JPA will obligate the county to give $34.7 million to the DOT this year. In return, DOT will repay that principal of $34.7 million to the county over a 2-year period beginning in July of next year.
And Madam Chair, yes. Chris, that's for phase 1.
That's for segment 1, the 82nd to 66th.
And that's without interest?
Well, I'm going to get to that.
Okay.
Yeah.
So we're really looking at 3.5-year payback, though, rather than 2 if it starts July of next year.
The payback of the 34.7 will begin in July of 09.
That's the cheap.
So we're looking at 3.5-year payback and not 2 years.
Well, yes, if you look at from when the funds are actually dispersed, yes.
Okay.
What the $34.7 million does is it actually secures the construction funding and the schedule for segment 1, and the construction of that project would begin in May of this year. Without the county advance funding, in other words, if we didn't do this advance funding, the State Road 60 widening for both segments would probably be delayed several years, if they would be done at all. Also in March of last year, to address the issue of the potential loss of interest earnings on that $34 million, the board enacted the State Road 60 interest share fee ordinance. This ordinance assessed a fee on all new development, commercial, residential, all new development that was brought forward within an 8-mile radius of influence of State Road 60. The segment 1 interest share fees that were imposed by this ordinance, they're already being collected because the 82nd to 66th segment is already over capacity. So staff started collecting those segment 1 fees last year, and as of January 3rd of this year, we've collected just over $250,000 in interest share fees. These fees are paid when someone comes in to pull a building permit and pays their impact fees. They also pay the State Road 60 interest share fee. Staff's analysis of the DOT agreement when it came forward to us, we've looked at it, and one thing that we noticed right out of the box is that the construction cost estimates for State Road 60 have dropped substantially since we looked at it back in March of last year and when the interest share fee ordinance was first adopted by the board. The original segment 1 fee was estimated, or segment 1 construction cost was estimated to be $38 million. That has now dropped to $34.7 million.
Mr. Moore, would you still say that's high in light of some of the bids we're getting?
No, not, well, DOT projects are normally a little bit higher than county projects because they do a lot more, they fold a lot more engineering effort, CEI, engineering inspection is all folded into that. Also, they are dealing with much higher traffic volumes, and keeping traffic rolling on roads like State Road 60 is more expensive from a maintenance to traffic standpoint. And I think if you look at the plans and look at what they have to deal with, there's an existing canal along the south side of State Road 60. They're going to be piping about 80% of that canal with anywhere from a 60-inch diameter to an 84-inch diameter pipe, depending on where you are within that drainage basin. But there's some significant costs, and they have to rebuild all the traffic signals and put up new mast arm signals, so it's an expensive project. But as I mentioned, the cost has come down for that segment from the original $38 million estimate to $34.7 million, and also for segment 2, which was originally programmed to cost $30 million, that's dropped almost half to $15.4 million.
Staff, this is an estimate. No matter what it is, do we have to pay it? Or,
These
is this
yes.
The most or the least we have to pay?
These are estimates based on their plans. Now, the segment 1 cost, 34.7, is very, very close to being what it's actually going to be, because they're very close to construction.
Right, but not on the 15.4.
Not yet, but that's their best estimate to date. We'll be bringing that JPA to the board later this year, and we'll get a final cost estimate on that at that time. Another thing that they have adjusted in the agreement is they've matched the repayment schedules for segment 1 and segment 2 to match payback schedules that were used in other counties. We ended up with an 8-quarter or a 2-year payback on segment 1 and a 5-year payback on segment 2. They've also, we've negotiated some other terms in the agreement that were beneficial or favored the county, in that they've allowed us on segment 1 to stagger the $34.7 million payout a little bit. We're going to be giving them 10% within 30 days of execution of this agreement, another 40% when the bids are let and advertised, and then finally the final 50% when the contract is awarded to the successful bidder. So we've got about a 5-6 month staggered payout that helps us in the interest loss category when you look at actual county costs. Another thing that they've done that they originally were not going to do, they're going to deposit our funds, the $34.7 million, into an interest-bearing account and allow that interest to accumulate, and it will be paid back to us in those 8 equal quarterly payments along with the principal. So while it is not paying interest as you would for a conventional loan with a term and an interest rate, by depositing it into an interest-bearing account, we are getting some credit for those funds being held outside of the county's hands.
Good.
Going back to the interest share fee ordinance, when we originally looked at the costs using the $38 million and $30 million figures that were originally proposed, we had calculated a potential interest loss to the county of $14.5 million. Now that we've looked at the lower construction costs and the staggered payout in the interest-bearing account, that figure has dropped overall to just $8 million in potential interest loss. How will that impact the State Road 60 interest share fees, the fees that we are charging to developers? They would actually drop. The segment 1 fee that we are currently assessing and developers are paying would drop from $76.77 per peak hour trip to $58.84 per peak hour trip. So that's about a 24% drop in fees there. The segment 2 fee, which we are not yet charging, but we will probably be charging some point in the near future, would drop more than half, from $17.731 to $82.74 per trip. And again, this is all due to the lower construction costs and the more favorable funding terms that we were able to negotiate. Staff's recommendation is to have the board approve the locally funded agreement, have the chairman sign it, so that we can proceed with widening State Road 60 to 6 lanes this year and begin construction in May of '08. We will also need to have the board, or we would like the board to direct staff to go ahead and amend the State Road 60 interest share fee ordinance that was passed last year to and adjust the fees to reflect these changes in the advanced funding arrangements. And we would be bringing those fees downward, as I mentioned in the previous slide, to reflect exactly what the advanced funding is now.
There are questions.
And that concludes my presentation.
Thank you. For questions now, Commissioner Wheeler.
If I'm following, the money that's already collected, the $271,000, will that be adjusted?
Yes, we would, being that the fees will, for segment 1 will be dropping 24%, we would have to refund 24% of that money back to those that contributed.
Okay.
Commissioner Davis?
No, ma'am.
Commissioner Fletcher?
No, ma'am.
Just one question on that. And I'm all for, if we can get their costs down, I think that's great, and if we can reduce the interest costs. But would we be better off just waiting to do that until we get the second agreement signed and kind of nail down that pricing so that we don't have to maybe change it a third time down the road? I'm just trying to think if we
might be better to do it when they award the bid, so as we know what the actual price is.
That's what I'm thinking. If we wait on that until the second bid, then we know exactly how much money we've put out, and then can recalculate the cost at that time.
And if we commit into this right now, does that automatically commit us into the second phase?
No. The second JPA will be a second locally funded agreement that staff will bring forward probably in October of this year. But that will be a separate 6-laning project that would begin in 2010. So the project would be separated by about a year as far as construction dates. But DOT is on a very tight time frame in getting this first segment out to bid. They're looking at March as far as getting this out to bid, which doesn't leave a whole lot of time. So that's why they're actually here today, and they're anxious to get us to execute the agreement and move forward with it.
Okay. Do you have anything to offer or say?
Good morning, Betsy Jeffers, Department of Transportation, District 4, Project Manager for Design for State Road 60. I just like to mention, like Chris say, that we are on a tight schedule and we're ready to let the job. It's, I believe it's already being advertised, and we still don't have an agreement for it. So we've managed to let our controller advertise and everything without the agreement or the money. Typically, we have to have the money in hand before we advertise. So we would really like the agreement. And then I guess the second issue is your issue, and it's up to you if you want to wait till later or not. But that's it. And if you have any questions, I guess I can answer.
Any questions? No. We're glad to see a face with the name.
I'll make a motion.
Okay.
That we move forward with the agreement with the state, and that we as Peter suggested and Mr. Baird suggested, we hold off on the refunds until we find out what the actual cost is.
Second.
Okay.
Any further discussion? All those in favor?
Aye.
Opposed? Passes 5-0. Thank you very much. We'll see you down the road.
Chuck, say something.
Mr. Meckling would like to speak.
Yes.
Chuck Meckling, 1999 Point West Drive. I'd just like to take a moment to comment both with Chris Mora and Joe Baird, as this has been a long ongoing process, and they've never dropped the ball in trying to work with what the numbers are actually, and it's been a process that you can see that the numbers have come back to something that's in the realm of reality. And I just want to take a moment to say that they've spent a lot of time on it. I'm very appreciative of the amount of time and diligence they placed upon this issue, and that the commission was well served for their dedication to that. Thank you.
Thank you.
Thank you, Chuck.
Utility Services, San Sebastian Springs Subdivision, Indian River County Project Number UCP 3014, approval of work order number 6 to retain a Carter Association for Surveying Services.
Move approval.
Second.
All those in favor?
Aye.
Opposed? Passes 5-0. Thank you very much. County Attorney's Matters. Resolution delegating authority to the county administrator to or designee to call letters of credit and road maintenance security issue under Chapter 934, excavation and mining of the Code of Indian River County, memorandum dated January 9th, 08, 198 to 201.
Move approval.
Second.
Any discussion?
Yeah, I'd like to have some discussion. In light of this morning's earlier hearings, what this will do is allow, under our ordinance, the board can delegate certain duties to the administrator. And in this case, it would delegate the authority to call letters of credit relating to road maintenance security or compliance bonds, anything related to mines. This morning, we saw that there was some issue as to whether the appeal should be heard this morning or later after a written appeal was filed. And one of the reasons that this resolution is coming forward is we've had a lot of delegation in the past of construction security for subdivisions. We haven't had that many issues with mines until recently. What this would do is, if the department found a violation, it would authorize the administrator to call the letter of credit without coming to the board. And then if there was an appeal, the appeal would come to the board subsequent to pulling the letter of credit, and you could determine whether a refund would be in order. What the practical effect of that will be, I think, is to put some of the issues that you addressed this morning as to what's equitable, is the violation significant. We'll push that decision to the administrator, and he'll have to make the decision whether he wants to exercise that authority to call a letter of credit or not, but it gives him the ability. And in this case, the violation was 6 days ago. The action was taken today. The conditions that the staff found were in violation could continue during that time. This would give the administrator more leverage to stop the offending operators more quickly, but it would still allow an operator to make appeal to you for a refund at a later date. That's all I'd like to say.
Commissioner O'Brien?
Yeah, and Will, it was actually the letters of credit from the banks that required the resolution of the board. Would the banks accept this as in lieu of a resolution from the board, or would they still say, no, we want a resolution from the board?
Well, what we'll do going forward is amend the language in the letters of credit to authorize calling them upon a letter from the county administrator or under the authority of this resolution. I'm not sure I'm answering the question completely.
But no,
the ones in existence would still require a resolution. If we have one existing that says there will be a resolution, a letter of credit that says there will be a resolution by the Board of County Commissioners, that has to be. We will reword the new letter of credits to say upon signature of the county administrator. Okay. So that's how it's probably going to have to work. Is that right?
Okay. Any further questions?
I kind of like the process we had this morning, even though it seemed a little encumbersome. I'm not sure I want to put all that on Joe's shoulders, quite frankly. And I think what we did today was right. I think we made the right decisions as a board, both one up, one down, kind of. And I think as the elected officials and stuff, we should continue making those decisions.
You know, I think you might be right. After this morning, you know, we pulled it. They had time to bring information in before it was, you know, we put them on notice of pulling it, and it gave them some time to bring in. It brings in a formal meeting, and I think you might be right after this morning. So I have to agree. It's a more fair process.
I'll withdraw my motion.
Commissioner Fletcher, did you have any?
No further.
Commissioner Davis?
No, ma'am.
And did I hear you right?
I withdraw my motion.
Okay, so I guess you agree too.
I do.
Okay. Do you want to make a motion?
I guess move to not approve the resolution.
Second.
Any further discussion? All those in favor?
Aye.
Opposed? Thank you very much. This is government at its best.
I concur, Madam Chair. I think, again,
I would have probably been-
what we did today I thought was fair and right.
Yeah, what might have got us, I would have been very more heavy-handed today, and I don't think that would have served y'all well, to be honest with you.
Okay. Emergency Services District, approval of the minutes of regular meeting December 18th.
Move to approve.
Second.
All those in favor?
Aye.
Passes 5-0. Thank you. Approval of FY 2007-08 EMS County Awards Grant. Purchase of capital operating equipment using non-matching EMS grant funds and grant resolution.
Move to approve.
Second.
Any discussion? All those in favor?
Aye.
Passes 5-0. Thank you. Solid Waste Disposal District. Approval of the minutes of December 11th, 07.
So moved.
Second.
Any discussion? All those in favor?
Aye.
Passes 5-0. Approval of the minutes of regular meeting December 18th.
Move approve.
Second.
Any discussion? All those in favor?
Aye.
Passes 5-0. Public announcement for an annual electronics recycling event on January 26, 08.
Madam Chairman, I'll move for approval, but I'd like for a little bit to go ahead, something I think we ought to take advantage of a little bit of time here.
Okay, can I have a
Right,
second?
absolutely.
Second. And we have a little bit of an error. We have 16,000 tons, and we meant 16,000 pounds. So that's just a typo. So
Well,
if we want
that
to
might
make
be
it-
optimistic.
Yeah, that's a little different.
There's nothing wrong with optimism.
Good morning, Commissioners. Himanshu Mehta, Indian River County Solid Waste Disposal District. We're just excited to announce to you and to the public our annual electronics recycling event. It is scheduled for this month, January 26th. It's going to be held at the Indian River County Mall on Saturday from 9 a.m. to 3 p.m. This event is free to all residents of Indian River County. Again, we encourage residents to bring their outdated computers, televisions, consumer electronics, and keep these electronic waste, out of the landfill. Again, last year's event, it was 16,000 pounds that we collected. And this year, I just want to mention ComCycle. They're out of Melbourne, Florida. They're providing this free event to the community. They're going to transport all their electronics to their facility in Melbourne, where they have a zero waste to landfill policy. Everything will be disassembled, recovered into components for resale or recycling of metal, glass, and plastics. They're going to provide us a certification of recycling. And important thing for residents to know is that they have a strict policy on removing and erasing all computer files, software, and other sensitive information on their hard drives. Also, ComCycle, as an incentive, is donating a refurbished laptop as an incentive to the event. Each resident will be provided an entry ticket for turning in electronics. They don't have to be present.
This on the overhead?
Sure.
I think this is a great service. And, we'll put this on our website. Yeah, you've got it. Put it on our website, too.
Yeah. I got it.
With over 138,000 residents, if we have perfect attendance, we might meet Joe's expectation.
Oops.
Too much. Can you zoom that out a little bit? There we go.
Yeah, it shows what they will take and what they will not take.
Yes, TVs, computer monitors, scanners, printers. We don't want microwaves and refrigerators and air conditioners and such. Also, just want to thank Simon Mall for donating the mall area. Also, they're going to be providing some coupons for the event. And just wanted to take a moment to quickly announce or introduce the board. Melanie Jones, she's with Keeping Indian River Beautiful. And as part of our scope of services, CURB is going to be hosting the event. They're going to provide education and information to residents. Also, we're going to provide recycling bins at the event as well. So it's just another community service that they're going to provide. Going forward, what I'd like to do is come back to the commission at a future event, give you an update on how the success of this event, and also bring back some recommendations for looking at companies to provide this type of recycling to the community throughout the year. What we could do is provide this at the landfill and possibly maybe our centers as well. I've seen other landfills have contracts included with companies where they'll continue to provide this type of an annual event. We could even consider having one again at the mall and maybe one at the, in Sebastian or something like that. So again, just give residents more opportunity to recycle their electronics.
I think this is an excellent idea, and it's one that will continue to escalate.
Yes, yes.
I'd like to move a hearty well done and congratulations.
Thank you.
Thank you.
And to just along those same lines, an event that you may be interested in coordinating one of these with is whenever we do our surplus auction. There's pallets upon pallets upon pallets, and that quite often bidders will just buy it for one or two pieces that's wrapped up in the pallet.
Right.
And the rest of it goes to our landfill. And so it may be a good event to have one of those at the end of one of those surplus auctions, because you got the school board there with their surplus computers, every municipality in the county, mosquito control.
Okay.
Great. Sounds good. Do I have a second?
Second.
All those in favor?
Aye.
Aye. Opposed? Passes 5-0. And we have Wesley's commissioner members of board of request to travel expenses. Wesley?
Yes, this is not for me. What this is a recommendation, commissioners, from the Agriculture Advisory Committee. You had the opportunity during the moratorium on the mining issue to see a workshop or a PowerPoint presentation that was given by Dr. Sidney Backus. And the Ag Advisory Committee would like for Dr. Backus to come down and explain in depth a little bit, and perhaps be able to field some questions about her hydrology report regarding mines and pits in particular. And this was a recommendation for from the Ag Advisory Committee to cover up to cover the actual expenses, travel expenses only, of her coming down for the presentation. And I felt it would be incumbent upon me to bring that forward since it was.
That's an excellent idea. Do I have a motion?
I'll make that motion.
Who does she work for?
Don't know.
Is she a consultant? Or
Bob?
Is she just coming to give us a presentation, or is she coming as like a consultant to try to sell her services?
My name is Robert Adair, Chairman, Agricultural Advisory Committee. We discussed this in our committee, as Commissioner Davis indicated. She has a PhD in hydroecology. She did the paper that was the backbone of the presentation that I presented to P&Z and to the County Commission. She does work as a consultant. She has consulted in Dade County for the Lake Belt region. She also has consulted in Lee County and I believe in Putnam County. She's personally interested in this. This is her area of research. She told me that she would come here to look over the issues to see what was involved if we would cover her travel cost. I have not discussed with her fees or doing any additional work other than that. Basically, as I see it, she's going to give us a quick opinion of what she sees and what concerns she feels there may be.
I agree with everything that they're recommending and they're trying to do. The only thing that concerns me is setting some kind of a precedent where we're going to start paying consultants to come and offer their services. I mean, generally, they come and offer their services and we listen and decide what to do. But I'm a little concerned. I know we had Michael, what's his last name? Bob, the Round Island guy, the Walrus. And, he came down from Jacksonville and stuff. In fact, he asked about travelers. I said, normally we don't do that. It's just, we would like your input, and if we use you, fine. But I don't want to set a precedent. We deal with a lot of consultants, and if we start paying consultants to come and tell us what they can do for us before they we hire them. I'm a little concerned about that.
Madam Chair?
Yes.
Commissioners, you're not going to hurt my feelings either way, but this was something that the Ag Advisory Committee voted on, and in light of the situation, I felt like as the liaison, I needed to bring that opinion or that vote forward for y'all's consideration.
Well, I think it's a good thing that we do this periodically. If they can pay their own way, fine. If they can't, and we still need their input, I think we need to be well-rounded and well-versed. And he did bring this to us. He'd done a lot of research, but he's not the expert, and I'd like to hear from the expert.
The one thing, just Commissioners, if this helps you at all, the one thing that this hydrologist is saying versus the hydrologist that issue and approve our permits for mines is this hydrologist gives evidence or has done research and has formed the opinion that a pit is a liability in a water user. The permitting agencies that grant our permits believe that a pit is a asset or an asset. So as far as a gain of water versus a loss of water. And so that's what did raise my, and I really would like, somebody from our permitting agencies, when I say that I mean St. John's, and explain why this is wrong, and if they're going to be down here at the same time, I'd like the debate to rage, because it's certainly raging in front of us on a weekly basis with our mining applications.
Yeah. Well, my only comment would be we tie this in. We just voted to have P&Z kind of take the lead on this whole process, and I think we ought to tie this in with a scheduled workshop, and we'll have other environmental hydrologists there, and as Commissioner Davis said, let the dogs fight it out.
Hash it out.
Yeah, absolutely.
And I trust that the Ag Advisory Board would do that. I believe that we're in the shallow end of the dream pool of information in hydrology. We often hear of the different modes, reports, and I believe that we have to support our Ag Advisory Committee and ensure that we have the best in information for the citizens of the county. So I remain my second.
In fact, I have no objection to anything that's said other than paying a consultant to come and show us their wares. And I think she's probably a good consultant. She'd probably serve our needs and our purpose, and maybe she ought to put in an RFP or a, and we ought to look at hiring her if we're going to need this consultant. But I'm just a little concerned about, we deal with a lot of consultants, and a lot of consultants are looking for our business and everybody else's business, and if we start paying them to come and I just have a principled concern with it. I think that probably the idea is excellent and her information is good and that we need to hear it. I'm just concerned about setting a precedent.
Yes. Well, the fees, my fear is that the fees would pale the travel expense.
Well, if she comes and travels and we like what she say, we may hire her anyway.
Then we'll just deduct that from her, from that house.
Are we going
Either way, we need the expertise.
I just brought the recommendation forward, Commissioners.
Right. And I'm not aware that we're in the mode of hiring anybody.
Well, I'm just saying that this isn't the way we've done business in the past. We're changing our procedure if we do this.
We haven't had the challenges we've had in mining in the past as well, nor a moratorium.
Commissioner Wheeler is right. We haven't done it in the past, but in this particular case, that we haven't done it in the past. He is correct there. It's been our policy, but in this particular case, I think they're going to share information free or something. But we've got to be careful. He is correct that a lot of consultants would love to be paid to give a presentation to try and sell their goods, and we just got to be cautious.
Yep.
So do I have a motion?
I'll move the recommendation of the Ag Advisory Committee.
And you still have a second.
All those in favor?
Aye.
Aye. Opposed?
Aye.
Passes 4-1 with Commissioner Wheeler objecting.
I'd like to make it clear and reiterate.
You did. You did.
Yeah, this has nothing to do with their expertise. It's a matter of principle.
Thank you. Meeting adjourned.